Good morning, ladies and gentlemen. I'm calling the meeting of the Illinois Prisoner Review Board together this morning on April 24th to consider the issues of Hickson, Woodson, Eddie Pitts, and Norals. Amy, would you please call the meeting? I'm going to call the meeting of the Illinois Prisoner Review Board to order. Do I have a motion to open the meeting? Motion by Tyson, seconded by Coates. Those in favor of the motion respond by voting aye.
Aye.
Aye. Amy, would you please take the roll?
Mr. Boland.
Jared Boland, appointed out of Macon County, present.
Mr. Coates.
Good morning, Matt Coates, appointed out of McLean County, present.
Ms. Globoker.
Julie Globoker, appointed out of Cook County, present.
Mr. Grubbs.
Jeff Grubbs, Jackson County.
Mr. Heaton.
Roger Heaton, Cook County.
Ms. Terronez.
Good morning, everyone. Carmen Terronez from Cook County.
Ms. Tyson.
Good morning. Crystal Tyson, Saline County.
Mr. Tupy.
Ken Tupy, appointed out of Sangamon County. Eight members appearing to be present. I'm going to open the meeting to order. I have a motion to approve. Do I have a motion to approve the board minutes? Do we not? No motion for that. Okay, Amy, would you please call the first case? Oh, okay, Ellen. I would first have the board members. Well, we'll open. Ellen, go ahead and open the meeting. Call the first case.
Falonzo Hickson.
It's been brought to my attention that the attorney who's supposed to be sitting with Mr. Hickson is having some difficulty getting into the institution right now. Falonzo, do you know, have you heard anything about how long it may be? Or is there an officer in the room who may be able to answer this?
Yes, ma'am.
Yeah, they're, she's at the gate right now, and they're bringing the gate pass down so that she can come in.
Okay, thank you.
Well,
Sounds like it'll just be a couple minutes.
correct.
So do you want to wait, or do you ready to present, Mr. Coates?
We can present.
Okay.
Yeah, I'll present. Okay. All right, good morning. On March 19th, 2025, I interviewed Mr. Falonzo Hickson via WebEx video at Danville Correctional Center. Mr. Hickson was present with his attorney, along with Jennifer Lackey, Jerfa Gerlin, John Ziegler, and Brian Johnson. A day prior to Mr. Hickson's interview, I spoke with Dr. Brooke Krishar, a forensic psychologist who conducted a forensic psychological evaluation on Mr. Hickson. I will share details on her report and more details regarding the behalf testimony that I received during his interview later in this presentation. Mr. Hickson's interview began at 9:04 a.m. and ended at 11:35 a.m. Mr. Hickson was put together with a blue buttoned-up shirt and prepared for the interview. Mr. Hickson presented a positive attitude and demeanor for the duration of our interview. He answered every question I presented and was a very articulate and productive communicator. Mr. Hickson shared he felt he was in good physical condition. The only presenting issue that he is having is with his loss in hearing in his left ear. In 2014, while at Stateville, a roach had crawled into his ear and caused an ear infection. And over the years, his hearing has gradually decreased, and he has had to receive routine treatment for it. He does use a hearing aid for that ear, depending on the setting he is in, so he can hear more clearly. In 2006, he had precancerous polyps on his vocal cords. He had them removed, and then they returned in 2013, and he had them removed. He had them treated and removed again. And those are the only major health challenges he spoke to. Regarding his mental health, Mr. Hickson shared he is a bit nervous for the interview. I'm not. There's no specifics here. Yeah. Mr. Hickson shared he's a bit nervous for the interview in 2017. Yeah, you know what, you're right. I will discuss that in closed session, so thank you for that. I'll move on. Mr. Hickson is currently 43 years old and has been incarcerated for 25 years and 5 months. Mr. Hickson is currently at Sheridan Correctional Center and is a medium security offender with a low escape risk. He has been on A grade since May 13th, 2024. In the year 2000, following a jury trial, Mr. Hickson was convicted of first-degree murder of Mr. Jerry Bringer and sentenced to 55 years in IDOC. Mr. Hickson filed a direct appeal, and the trial court's decision was affirmed. In 2004, Mr. Hickson filed a petition for post-conviction relief, and the trial court dismissed the petition. On appeal, the appellate court affirmed the denial. In 2016, Mr. Hickson filed a motion for leave to file a successive post-conviction petition and a successive post-conviction petition, arguing that due to his age at the age of 17, his 55-year sentence was a de facto life sentence. That same year, the court granted leave to file the successive post-conviction petition and ultimately dismissed it. On appeal, the appellate court reversed the trial court's decision in granting Mr. Hickson a new sentencing hearing. Mr. Hickson's new sentencing hearing was held on January 3rd of 2020, and he was resentenced to 35 years. Mr. Hickson appealed, and his appeal was denied June 6th of 2023. Mr. Hickson has an MSR date of July 26th of 2034. A little bit into his background, Mr. Hickson shared he is the middle child of 5. His parents divorced in 1983. He remembers growing up very poor. His mother struggled, and while his father was in and out of jail. But when his father did come around, he was happy to be in his presence. There were a lot of sad times with his mother as they navigated poverty and how they were going to eat. They lived in a 3-flat apartment building that his grandmother owned. They lived in the basement of that building, and up until he was about 9 or 10 years old, he stated he felt he was doing good behaviorally. Around that age, Mr. Hickson recalled observing his mother crying while having an argument with his grandmother about her not being able to pay rent. They were screaming at each other, and that crushed him, seeing his mother cry because she was unable to pay rent. From that point, he made a vow to help his mother never have to cry about money again. So he started taking small jobs such as raking leaves, shoveling snow, pumping gas, and small jobs he could do as a kid. While pumping gas one night, some older men drove up to him and told him to go home. After a conversation of why he was out that late at night, they shared with him if he wanted to make some more money, he could be their lookout. After having to be informed of what a lookout was, he was offered $50 to be a lookout for police, which was a lot of money to him at the time. He figured it would greatly help his mother, so he took that job. He started working security for local drug dealers. Every chance he could, he was taking his mother the money that he earned. The more he worked security, the more he became familiar with the individuals that were selling drugs. And then it reminded him of what he saw his own father doing out of his home, which was selling drugs. At that time, he thought that was why his father always appeared happy and always had money due to selling drugs. Being naturally influenced by that, Mr. Hickson began selling drugs as a young boy. Mr. Hickson's mother moved him to Trenton, New Jersey after his house was shot at while he was on the porch talking with some individuals he sold drugs for. They were talking when another car drove up. Words were exchanged between the people he was with and the individuals in the car, which led to them shooting at them towards the house. He was 10 years old at the time. While in New Jersey, he lived with his aunt and uncle on an army base. It was a strict atmosphere, and he felt he had adjusted well to it. Over time, he had become homesick and missed his family in Chicago. He started acting out, and knowing if he did, they would probably send him back home. And shortly after moving back to Chicago, he moved with his mother to Champaign, Illinois. At the age of 12, he was put in 5th grade, and his behavior started to change. He started to sell drugs as that was the only pathway to him to make money. He felt drugs was the best way to support himself at the time. In the months and days leading up to his offense, he was experiencing homelessness at the time and was couch surfing from one place to another. He figured if he was always supplied the party, drug, or alcohol, he would always have a place to stay. He found himself completing this cycle over and over, night in and night out. Each day he felt he needed to sell drugs, to purchase alcohol, to supply to people at parties so he would have a place to stay at night. He stated he didn't have direction at that time. He only had cousins in Champaign and no other family lived there with him when he went back down there from Chicago. Moving on to statement of facts. Regarding the statement of facts, there was no official statement of facts provided to our PRB agency after several attempts in requesting it. And now moving on to the statements as to the offense. In November 1999, at the age of 17, Mr. Hickson shared that he was still selling a small number of drugs at the time to support himself. He was starting to experience people turning his drugs down due to him having such small amounts. He started to become desperate and was losing opportunities for a place to stay. On November 12, 1999, Mr. Hickson was desperate to make a sale of crack cocaine due to needing a place to stay for the night. He was afraid he would be spending the night spending the cold night on the streets. Mr. Hickson saw Mr. Jerry Bringer, who was interested in buying the drugs. Mr. Hickson showed him the drugs, and Mr. Bringer took his wallet out, but Mr. Bringer said he wanted more than that, and Mr. Bringer said he wanted more than that than Mr. Hickson had at the time, and refused to purchase them. This interaction was taking place out inside of Mr. Bringer's car as Mr. Hickson leaned in from the passenger side window. At that time, Mr. Hickson's heart dropped as he was so close to making the sale. They argued, and in desperation, Mr. Hickson tried to grab Mr. Bringer's wallet. They began to struggle over the wallet when Mr. Hickson placed his drugs in his pocket and remembered he had a gun. Mr. Hickson thought he could show the gun to scare Mr. Bringer and then get his wallet. At this point during the interview, while Mr. Hickson was recalling his version of the offense, he became visibly emotional and took a minute to recollect himself, and then he proceeded. He goes on to state that Mr. Bringer, however, pushed the gun away, and in the heat of the moment, Mr. Hickson shot him, thinking he would be injured and he could just grab his wallet then. He initially thought he missed due to Mr. Bringer continuing to fight over the wallet, thinking if he shot him in the arm, he might drop the wallet. Mr. Hickson then shoots Mr. Bringer again, striking him in the leg. At this point, Mr. Bringer slumped over and he released the wallet. And Mr. Hickson was instantly terrified and jumped out of the car and ran without taking Mr. Bringer's wallet. Many days when he is reflecting on his past and when he recalls the offense, he plays that picture over in his head and he thinks of telling Mr. Bringer sorry and that he did not deserve that. That day can't leave his head. He has had a constant reminder that he took someone's life and he never thought he would ever have that title. While he was running away, he observed Mr. Bringer trying to put the stick shift car into gear, attempting to drive away, and then crashing his car. Afterwards, he ran over to give the gun to one of his older peers, to which he called his OGs, and he did that not knowing that the individual was a police informant, and that individual police informant turned him into police, which led to his arrest. And I would like to, at this time, go into closed session to discuss some privilege items. Aye.
Ladies and gentlemen, I'm going to ask you to leave the room temporarily. Take all your belongings with you, and we'll have somebody call you back in when we're finished. Okay, we're going to return to open session. You wish to continue, Mr. Coates?
Yes. All right. Thank you all for your patience. I'll now move to institutional adjustment. So starting with the disciplinary tickets, Mr. Hickson received 30 tickets total during his incarceration from 1999 to the present day. His first ticket occurred in 2001 for insolence. His sole fighting ticket came in 2002. Many of his tickets range from disobeying a direct order, unauthorized movement, theft, trading or trafficking, and contraband. Some of the tickets that stood out to me as being particularly concerning were his 2013 gang unauthorized organization tickets with the comments of STG literature, and his 2019 ticket for gang or unauthorized organization activity. I asked Mr. Hickson about both of those tickets, to which he shared regarding the 2013 ticket with magazine and books. There is a publication system where they approve or deny magazines. He had the book The 48 Laws of Power and The Art of War magazine. When he first purchased those books, they were not on the ban list at that time. Over the years, they became on the ban list, and so when an officer would complete shakedowns and then his cell was searched, if those books were found, they are ticketed, and those tickets fall under the range of STG literature. Mr. Hickson assured that none of those books had anything to do with gang involvement or anything of that nature. Regarding his 2019 ticket for gang or unauthorized, unauthorized organization, Mr. Hickson shared he worked in the school and he earned his GED in 2017. And in the process, he had the opportunity to be a teacher's aide. He took the job. While working in the school, someone had asked him to make copies of paperwork for him. A correctional officer shared with him that as long as he had the other person's ID and money voucher on him, he would be able to make copies. Another officer searched him and found the other person's property and ID. Also on his person was his sister's obituary, which he always had on him. They made a custom obituary about her life with several pictures, and the officer believed the images on the obituary were to be gang-related and issued him this ticket. Mr. Hickson's most recent ticket came in February of 2024 for insolence. Moving on to his programming, Mr. Hickson has a very positive programming and rehabilitative history. Mr. Hickson began engagement with programming in 2014 when he, for the first time, gained access to programming. In the years prior, he was denied due to his release date. And Mr. Hickson earned his GED in 2017. And in 2018, he was accepted and enrolled in the highly competitive Northwestern University Prison Education Program. His time in the program was halted due to his resentencing process. However, he has been re-enrolled in that program as of 2024. He currently has a 3.4 grade point average in that program, and Mr. Hickson has over 13 programming certificates and 8 earned program sentence credits certificates. And Mr. Hickson has completed the anger management course twice and has completed drug awareness program in 2021. The more he learned and participated in his education and programming, the more he has enjoyed and developed a love for learning and helping others during the process. He shared with me he takes great pride in his education, and Mr. Hickson was able to articulate his involvement and his understanding of masculinity and vulnerability. He shared the value in learning about his traumatic past, his behavior, and understanding his thinking as a youth. Mr. Hickson shared he takes great pride in being the first person in his family to graduate from college and plans to continue his educational journey at Northwestern if paroled. Mr. Hickson has worked several jobs since he's been incarcerated. Some of those roles include working in the dietary department, being a painter, a laundry porter for his unit. He was also a staff cook at Pinckneyville for 2 years, which is a very trusted position. His top 2 jobs were being a teacher's aide and being a staff's cook. He is currently not allowed to work due to being a full-time student in the Northwestern's program. And next, I would like to briefly share some testimony that was given from the individuals that spoke on his behalf during his interview. First, Jennifer Lackey, a professor of philosophy and law at Northwestern University. She is also the founding director of the Northwestern Prison Education Program. She testified that the Northwestern Prison Education Program launched in 2018, and Mr. Hickson was a member of their first cohort of students. It was a very competitive and rigorous process to be accepted into the program. Last year, they had over 400 applicants throughout the state and only accepted 20. And one of the things that really stood out to her about Mr. Hickson is how teachable he is. Specifically, how receptive he is to feedback, how receptive he is to growing, and how he incorporates that into his work and into his life. Many students have struggled growing and overcoming intellectual or academic blocks or letting go of habits, and she was pleased to see that he did not have any of those challenges. She also explained he is a community builder, and he builds strong relationships within the community and lifts people up. Their program cohort model, which means that all 20 students spend each class together, and they all live in the same cell house together. If Mr. Hickson is released, he will be able to use this program as a resource in multiple ways, as he will be able to remain a student cost-free. He would also have access to all of the university's resources on campus, such as the library, the gym, the writing lab, and that's just to name a few. He would have free mental health care at the Family Institute at Northwestern, and also connection with the mentorship with alumni. She said he is about 1/3 of the way through the program. When he started in 2018, shortly after he was forced to drop the program due to him being remanded for resentencing. Once that process concluded, she worked for several years to get him back into the program, and he started the program again in 2024, and he had to re-enroll. He had to go through all the application process all over again. In her time with him, she feels he is an outstanding candidate for parole, and they are prepared to support him in any way he needs support upon release. Next, Jerfa Gerlin, who is a graduate student at Northwestern and a volunteer with the Northwestern Prison Education Program. She has known Mr. Hickson for about a semester, and he is easily top 5 when it comes to thinking about an impact that a student has made on her. She shared with me, normally speaking, she would not feel comfortable providing a support in this way due to knowing it takes time to build rapport and trust, given the short amount of time she's known Mr. Hickson. But in her engagement with him in just a few hours a week, one thing that stood out to her about him is in his ability to be vulnerable. Talking about his emotions, talking about complex feelings, discussing his past, which is tough, they are able to talk to the fullest extent about growing as a person and nurturing that vulnerability. That is a skill he wants to continue growing within. His dedication in promoting vulnerability for men that are around him, his dedication in promoting vulnerability for men that are around him and helping create a space for introspection has deeply moved her. It speaks to his skill as being a community builder. His ability to uplift other students to help them along has been impactful. And she feels he will apply those same strategies upon release. Next, John Ziegler, the director of the Egan Office of Urban Education and Community Partnerships at DePaul University. He is also an instructor in the Inside Out program, among other courses. He was part of the initial cohort of the Inside Out program at Stateville. He helped students have an intellectual conversations about their own life, decisions, challenges, and connecting to a change in thinking. He teaches masculinity, justice, and law course. The main piece, his course provides an opportunity for students to look at society in a more robust way. Specifically, his goal for his students is to be a part of the solution in solving problems, community problems. He had Mr. Hickson in his 2016 class, and his class was project-based. Mr. Hickson was a phenomenal student. He found him to be a curious student that asked a lot of questions. He loved the process of learning new information and he took every opportunity to ask questions. Mr. Ziegler was moved deeply by his selfless attitude and reflections when looking over some of his writing examples. What stands out most to him is he's always thinking of others instead of himself. Mr. Ziegler felt Mr. Hickson would be very successful moving forward in what he chooses to do. And lastly, Dr. Brooke Krashar, a forensic psychologist who conducted a forensic psychological evaluation on Mr. Hickson in March of this year. She spent about 5.5 hours with him during his assessment, diving into trauma he sustained in his youth, his work towards rehabilitation, his current outlook and mindset, his risk levels upon release. The summary of her assessment, and I'm merely summarizing it, noted that Mr. Hickson's behavior and adjustment in prison suggests that he will not require much in the way of professional service plans designed to manage violence risk. He scored low in her assessments that pertain to risk factors. Her report stated his compliance in prison further indicates that he should have minimal difficulty with adhering to conditions of release. She found it to be noteworthy to share that Mr. Hickson plans to live at St. Leonard's rather than live near his family, which may still present negative influence to him. His decision to parole where he will receive the most support is positive. Lastly, Mr. Hickson's ability to ignore negative influences in prison, as well as his commitment to education and personal development, should mitigate any risk he may encounter during parole. This statement referred to research that suggests risk factors are higher for a person upon reentry if they are living in a shelter or halfway house, as opposed to living with family. After touring St. Leonard's myself, I can affirm that it is a positive reentry environment. Mr. Hickson also had 3 letters of support from his peers, including a meaningful one from his son. Moving on to parole plans. Upon release, Mr. Hickson plans to enter St. Leonard's Ministries in Chicago. This is corroborated in his petition, as his file contains a letter from St. Leonard's stating he has been screened and approved for placement once he is paroled. He wants to be closer to the Northwestern campus in Evanston so he can utilize the resources on campus. Mr. Hickson will also receive support from Eric Anderson at Precious Blood's Ministry, along with strong support from the Northwestern University program. His son, who was 26, he shared and is a security guard in Chicago, and his son is having his first child, and he wants to be a positive grandfather. He wants to be close to his son and be a part of his everyday life. He shared with me when he went off to prison, his son was about 6 months old, and so he wants to further that relationship and be more a part of his everyday life. I did not see in the file opposition to parole release this time. And then on Banc history, this is Mr. Hickson's first time appearing before the board for parole consideration. And Mr. Tupy, that is my conclusion of my presentation. I yield back to you, and I'm happy to answer any questions or defer to his counsel, Ms. Jackson, for her presentation.
Does anyone have any questions for Mr. Coates at this point? All right, then we'll turn it over to the attorneys to make their presentation, and then we'll open it up for questions.
Thank you, Mr. Tupy. Before I get started, I know we have a number of supporters here for Falonzo. Can I ask them to stand?
We actually need to swear all of you guys in as well. Mr. Hickson, can you also raise your right hand, please?
Do you solemnly swear that the testimony that you will give in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Yes. Thank you.
And we only have 2 people speaking on behalf, correct?
I've already worked this out.
With who?
Mr. Tupy, is it okay?
Will they stand? I thought you were going to have them stand.
Yes. May I ask that the Northwestern, the supporters here stand for Mr. Hickson? Included in the supporters are members of the Northwestern Prison Education family. Falonzo will have their continued support, as Mr. Coates mentioned. Included in this group are members of their reentry and wellness group, and immediately upon release, Falonzo will be connected with them and brought to the Family Institute that provides counseling free of cost for all Northwestern prison education students. I would like to add that we're here today in a really unique circumstance. Falonzo was resentenced at a time when the law was in flux. Buffer had just been decided, determining that in Illinois, a de facto life sentence is over 40 years for a juvenile. It had not even been in published form yet. Throughout his resentencing, the judge and the attorneys had conversations about what law applied, and they weren't sure. All 3 of them agreed that these would be issues taken up on appeal. Also, you have so much more information today than the sentencing judge had. At the time, he was one of the first resentencings. The judge didn't have the knowledge that this board has. It didn't have the benefit of how all of these similar cases would have been decided over the next few years. The judge only heard testimony from an IDOC official and Falonzo himself. Mr. Coates has heard from the people who interact with Falonzo on a regular basis. You will hear from Dr. Krausar, a forensic psychologist, about brain development and his risk of recidivism. You have a detailed reentry plan that the judge did not have. And Falonzo's sentencing judge was correct when he said that this board is the best body to determine Falonzo's release. Most judges have never been inside of a prison. This board has seen these facilities. You know how difficult it is for a young man to survive in maximum security institutions like Menard and Stateville, let alone thrive in the way that Falonzo has. You know the conditions of Stateville before it closed. You heard Falonzo has a hearing difficulty because a cockroach damaged his ear when it crawled inside. You know the challenges associated with attending school through the lockdowns, through the heat in the summer and the cold in the winter. You know the pressures to join or remain in a gang, and your task is different than the sentencing judge's was, but you are also better equipped to determine Falonzo's release.
Thank you. My name is Taylor Markison, and I'm an attorney with Reed Smith, LLP. About 1 year ago, when Marissa approached myself and Reed Smith about partnering on this case, we were immediately compelled by his story. In my work, I defend denials of insurance coverage under the Employee Retirement Income Security Act and Federal Mental Health Parity Act that involve children and adolescents who are institutionalized as a result of behavioral problems that my clients have determined are not in accordance with generally accepted standards of care. This can either mean that the facility itself does not meet generally accepted standards of care, often colloquially referred to as a troubled teen program, or that the child's condition is not severe enough to warrant continued institutionalization. My clients determine generally accepted standards of care, usually using nationally recognized peer-reviewed evidence-based guidelines with which I am familiar. I was disturbed to learn that Falonzo spent all but 8 months of his life from the age of 13 in a detention center for a drug possession case. Upon reviewing his case, I know that we would never do that to a child today. When Falonzo was released, DCFS had removed all the other children from his family's home. Falonzo slipped through the cracks because he was in juvenile detention. He returned to that home. Today, we know that incarcerating children that young and for that length of time does more damage to them, exactly like this. We know how disruptive this is to a child's formation. For that reason, it is at odds with all generally accepted standards of care, and any reputable, peer-reviewed, evidence-based guideline developed and used by a licensed behavioral health practitioner would not do that. We know that children who are incarcerated and institutionalized are 3 times more likely to be reincarcerated as adults. We know that this kind of continued detention of a child without any consideration of the child's actual condition creates a risk of entrenching them in behaviors that the system should be helping them escape. We know that all too often this results in acts of violence. Falonzo's childhood represents many failures of our system at the time. Falonzo now is a symbol of the best of our rehabilitative system. He excels in the Department of Corrections, committed to transforming himself, taking accountability for the tragic decisions he has made, and is genuinely remorseful, and he is earning a bachelor's degree at Northwestern University. Expert testimony is invaluable in my casework when deciding issues of whether continued incarceration and institutionalization is necessary for a person's continued incarceration and current risk of harm to themselves and others. For that reason, we provide the board and kindly request the board hear the testimony of Dr. Krausar.
Hi, thank you. My name is Dr. Brooke Krausar. I'm a forensic psychologist. I've been working in the field of mental health for about 30 years. I trained at John Jay College of Criminal Justice, as well as the University of Denver and Yale University. My areas of expertise are incompetency to stand trial, criminal responsibility, capacity to waive Miranda, trustworthiness of confession, juvenile waiver and certification hearings, as well as juvenile development. Adolescent development. I have testified 36 times in the state of Missouri and Illinois. In Illinois, I've testified in Madison County, St. Clair County, McLean County, Jefferson County. I will testify in Sangamon County later in the next couple of months, and in DuPage County, I think in August. Mr. Hickson is the 40th individual that I have psychologically evaluated who became eligible for either resentencing or parole under the Miller ruling and Montgomery rulings. Among those 40 individuals that I evaluated, I was asked to prepare a report that was later shared with the parole board or in a resentencing hearing 32 times because the results of the evaluation was favorable enough that an attorney felt it was important for a parole board or a judge to hear that. So that roughly amounts to 82% of these individuals who became eligible for parole or resentencing for murders they committed as juveniles have made significant gains in their psychosocial maturity and desistance from antisocial behavior, just as the science tells us is true. So in evaluations like this, I typically do a clinical interview and then I administer some risk assessment instruments. I did prepare a report regarding my findings with Mr. Hickson. Hopefully you've had a chance to read that. I'm happy to answer questions about it, but I can also briefly summarize my findings. So in the clinical interview, I'm asking all kinds of questions about their life history, but I'm also administering some risk assessment instruments. One of those is called the Hare Psychopathy Checklist. It measures traits of psychopathy such as lack of empathy, remorse, manipulation, callous behavior, glibness, superficial charm. In the Hare Psychopathy Checklist, the score can go from 0 to 40. Scores of 30 and higher are considered to be very high in psychopathic traits. Scores of 20 and lower are considered to be a distinct lack of psychopathic traits. And I should mention that the reason why I administer this instrument is because psychopathy is considered to be a risk factor. It's part of a risk assessment. So Mr. Hickson's PCLR score was 13.7, so 13.7 out of 40. That falls in the 18th percentile compared to other North American prison inmates. So that score is far below the prototypical psychopathy score, which is, again, designated as a score of 30 or above. There are also factor scores within that total score that measure different traits. There are 2 factor scores. The first factor consists of interpersonal and affective traits, like that measure selfishness, callousness, remorseless use of other people, lack of empathy, and Mr. Hickson's score on factor 1 was 4 out of 16. And so that fell in the 16.8 percentile compared to other North American prison inmates. His factor 2 score makes up more of lifestyle or antisocial facets. So we're talking about chronic, unstable antisocial behavior, sensation seeking, substance abuse, impulsivity. So individuals with higher factor 2 scores tend to be found to be higher at risk for future violence or recidivism in the community. Mr. Hickson's factor 2 score was 8.5 out of 20, which is in the 30th percentile. It's actually not unusual among this population to have a little bit higher factor 2 score because of the history of delinquent behavior during youth or different what we call criminal versatility during youth. We do have to take that into consideration in the scoring, so that can raise a person's score on factor 2, but Mr. Hickson was very low on impulsivity. He was low in stimulus seeking. He has been sober for 25 years, so he's very low on substance abuse. So those were factors that lowered his score. I also administered something called the Personality Assessment Inventory, which is a personality test that measures a person's current psychological functioning. It's an objective personality assessment that measures a person's psychological adjustment, their characteristic traits and behaviors, and it can provide diagnostic considerations. The test also has built-in validity scales that measure the examinee's honesty of responding and their test-taking strategy. So it measures whether or not the individual is paying attention to the test items and answering them in a consistent way. And it's also able to determine if a person is being honest in their approach or trying to manipulate how they come across. So for instance, it can pick up if a person is trying to lie or exaggerate their problems, or they're trying to what we call fake good and deny or minimize having any problems. So Mr. Hickson's profile showed that he appropriately attended to the items. He paid attention to what they meant. It also showed that he took a very honest approach to the test, that he did not try to manipulate the results in any way. When it comes to what's called negative impression management, which is exaggerating problems, he scored within the normal range. And when it came to positive impression management, which it measures faking good, denying problems, pretending to be better off than you are, he again scored in the normal range. So very, very honest in his approach. The clinical profile showed that he scored high in anxiety, which we would expect given that he participates in counseling and therapy at the institution where he's at, and he receives medication for generalized anxiety and an unspecified depressive disorder. So Mr. Hickson is what we would call worried well. He doesn't have any major psychopathology, but he does receive treatment for minor depression and just generalized worry. And he takes a low dose of an antidepressant medication and responds well to the treatment and is very compliant. But consistent with that history of being treated for depression and anxiety, his score was elevated in anxiety, just like we would expect. He also, the other elevation was in the area of alcohol and drug use based on his history, because he answered those questions very honestly. And so he was able to identify that his youthful problems with substance abuse caused a lot of negativity in his life and caused a lot of problems for him. But beyond that, his profile was relatively unremarkable, although I will say that even though he was very honest in his approach and did not try to manipulate the results in any way, the validity indices showed that he had kind of an idiosyncratic way of interpreting some of the questions, which caused him to score in some areas in a way that was not really consistent with how he presented. But because the validity indices showed that he was very honest and straightforward in his approach, those unusual findings seemed to be the result of interpreting some questions in a unique way. So for instance, one of the things that came up that I would not have expected, which was very inconsistent with his presentation, is that he came across as being kind of grandiose on the test, but he's not that way in person. He's confident in himself, but I guess the way he interpreted some of the questions caused him to score high on that level. And he also scored high in traumatic stress, which would be consistent with his history. The other thing that was a little bit unexpected is he scored very, very high in warmth. Like, this is a person who places a premium on having good relationships with others, getting along with people, having positive interactions. But he scored extremely low in dominance, meaning that this is someone who worries a lot about what other people think and maybe has a hard time being assertive even when assertiveness is warranted. I don't think that's quite how he is in day-to-day life, because I think there would be signs of that in his functioning. So again, I think that finding was due to maybe an idiosyncratic interpretation of some of the questions. But by and large, his profile was within pretty normal limits and is consistent with his history of being treated for minor anxiety and depression.
Thank you.
one more assessment.
Oh, and then I administered the historical clinical risk management. It's a risk management tool that looks at different risk factors to take into consideration when trying to anticipate what a person's future adjustment will be. So it looks at historical risk factors, it looks at their current functioning, and then takes that information and tries to help figure out what areas might be the most challenging for this individual. Now, even though Mr. Hickson had some of the historical risk factors based on his youth, based on the history of abuse, the childhood substance abuse, the exposure to violence in his community, and he did get into some fights when he was a teenager. Even though those things are historically relevant, that pattern of behavior didn't follow him into adulthood. I think I was reading in his records that he had 30 disciplinary tickets, but 19 of those happened prior to age 25. So again, just consistent with the science, that pattern of youthful behavior did not follow him into adulthood. Clinically, at present, there are very minimal risk factors. He has good insight to himself. He's very self-aware. He's very good at managing the mental health issues that he's dealing with. He's compliant with treatment and responsive. He's shown a good treatment response to it. He has described having a resilient attitude, and he uses that attitude to encourage other people to make positive changes in their own lives. The records and my assessment of Mr. Hickson shows that he really has no difficulties with his adaptive behavior, and he was selected to attend college, which is a privilege granted only to those inmates who have the best behavior, who also demonstrate the aptitude for higher education. He does not report or exhibit any hostility or violent ideation or intent. He doesn't experience sudden emotional disturbances or mood lability. Nothing in the evaluation showed that he's restless, impulsive, or destructive. So his future risk factors were relatively low. As was stated, he's not going to have any difficulty following a service plan. He's able to function well and follow the rules in prison, which means that he should be able to follow the rules in the community as well. So I think following those earlier years in the Department of Corrections, the results indicated that Mr. Hickson has occupied himself constructively and pro-socially. He renounced his gang affiliation. He's been sober for 25 years. He has skillfully managed his diagnoses of depression and generalized anxiety by complying with the treatment. His disciplinary actions since age 26 have been infrequent. There have been long periods where there were no infractions. For instance, I think the first 19 tickets happened by age 25. Between the ages of 26 and 30, he had 1 ticket. From 2019 to 2024, he had 0 tickets. So again, that's very consistent with the science, showing that people outgrow and desist from this behavior. He has completed his GED, enrolled in college, been very industrious in his work roles. He's held positions of trust. And so there was really not much in the risk assessment to show that he would be at risk to society. And then when you look into the static factors like his age, research has shown that the older people are when they are paroled, the greater their success on parole. Their adjustment in recent years is also predictive of parole success. And yeah, I think that's basically the summary of my report. Are there questions?
No. We'll open it up for questions in a minute, but I think you ought to have your client testify at this point.
Alonzo.
Yes, ma'am.
Has
Can you
he been
please-
sworn?
Yeah.
Yes, ma'am. Are you ready? Good afternoon, ladies and gentlemen. I hope everybody is doing well. I would like to start by thanking Mr. Coates On March 19th, he interviewed me, and just like today, I was very nervous. The whole process put me at ease, and I was able to open up about parts of my life that brought me to tears. But the most part was Mr. Coates listened and heard me. So thank you, Mr. Coates, for making me feel like a human being instead of an ID number. At the age of 17, I was far from the man who stands before you today. That 17-year-old was dumb and had no purpose or directions in life. On November 12, 1999, that led me to making the worst decision of my life. A decision that resulted in another human being losing his. The man that stands before you today takes full responsibility and accountability for my actions on that night. I have thought about my actions every day, and I wish I could talk to my younger self. I tell him to get out the streets and never touch a gun. For so long, I wanted to apologize to the Brenica family, but I never had the chance until 2019. After being told that I would have that chance to make a statement today, all I could think about was being grateful for the opportunity to apologize again in the setting that the Brenicas might see. But there is no words that can express how sorry I am. So to the Brenica family, I'm deeply sorry for my actions that took your loved one away from you. My heart sinks knowing what I've done and the pain that I've caused. It's a hurt that I must live with every day for the rest of my life. But it does not compare to the hurt that I know you feel. I ask for your forgiveness, and I fully understand if I don't get it. I want you to know I made personal vows, which is to always be apologetic and remorseful, and do my best to prevent kids from venturing down the same path I was once on. I really look forward to working with Precious Blood Ministries of Reconciliation and the Northwestern program to tell my story and show them how that path ends. My message is clear to today's kids. I have been down that path you on, and it leads to nothing but pain. The streets are full of lies and tragedy. I truly believe that because of my experience, the children will listen to me. I promise to never shy away from telling my story or answer any questions if it means preventing another family from experiencing the pain I've caused the Brenicas. I'm in a unique position of being able to talk about causing harm and experiencing it. In 2016, I lost my sister to gun violence. She was shot in the head by a 15-year-old boy. I can't help but to imagine how his life was growing up and what type of trauma he may have been through. In a pub further research, I found out that he had no father. His mother was in and out of prison. He was from foster home to foster home, as well as a runaway. A bad breakup between kids resulted in him finding a gun and fired into the same house that he often slept. My sister was hit in the head as she got up off the floor to shield my nephew who was on the bed. I'm sorry. After the boy found out what he'd done, he broke down crying because my sister treated him like a son. I pray he spend his time doing everything he can in order to better himself and educate himself on the dangers of guns. I hold no bad feelings towards him because I was like him. I understand him and I know how he felt. The same pain that I have caused, I have experienced. My sister died a hero, and I miss her every day. She is my motivation and inspiration in all my success, and she will continue to be. To the members of the parole board, I would like to let you know I appreciate this opportunity to be heard and have a second chance at life. a second chance at life with the tools that I have learned to use to be a productive citizen and to be successful. I'm very grateful to my family and to my friends, my Northwestern family, and St. Leonard's and Precious Blood Ministry. I'm grateful for the support. I would like to let you guys know that y'all contributed in some type of way to the man that I am today. I have no doubt in my mind that as long as I got y'all by my side, I would pass any test that life has in store for me. Sorry. Members of this parole board, if you can find it in your hearts to give me a second chance, I promise y'all I would not disappoint any of you. I thank y'all for the time and consideration.
Thank you. On to the board. If you have any questions at this time. Dr. Revoker.
Sure. We've heard quite a bit about your history in the institution, of course, some of the tickets, but also some of the positive activities that you've engaged in. I would love to hear more. You know, unfortunately, out here, homelessness still exists, joblessness still exists, all the stressors of life, and you know, how you anticipate supporting yourself, what you've kind of explored in terms of how to navigate some of the stressors on the outside. If you can share a little bit more about your role. Can you hear me?
Can you all hear us?
Board member Globoker, we're having a hard time hearing. There's a lawnmower outside, and I know that he's got a hearing disability, and the internet connection's a little choppy. Would you mind repeating your question?
Sure. First, I'll ask directly, just in terms of potential employment or supporting oneself. I know that's a challenge. If you can help ask if he's thought in terms of employment.
I'm sorry, you said you had a question about his employment. I apologize for the audio issue.
I'm sorry, just in terms of whether he's given thought in terms of the employment that he would seek after release.
Yes. Oh, yes, ma'am. I'm sorry. Yes, I spoke with the intake manager at St. Leonard's Ministries, and he assured me of the programs they had in place. And one of the programs was on-site training. He asked me what field I was good in, and I let him know that I had a certificate in custodial maintenance that I've received from juvenile prison, and I also continued that in here. So I do floors, buffing and stripping, and I'm also a cook. So he let me know that they have programs in place that can help me get to any one of those fields if I choose to, whichever field that I choose.
Thank you for that. And in terms of thinking about the stressors, the stress that individuals face on the outside, how do you anticipate dealing with those moments of stress?
Leaning on my family that I have with Northwestern and St. Leonard's. As I said earlier, I have no problem with asking for help when need. Northwestern has let me know that anything there's no limits, along with St. Leonard's and Precious Bloods. So I have no doubt in my mind that any type of stress or roadblocks I come across, I'll be able to succeed.
Thank you.
Any further questions? Oh, we got to find. Mr. Bolin.
Thank you. First, could you actually tell me what was the basis of the appeal of the resentencing decision?
There were a number of issues at the time that they were appealing, one of which was during that period there was a decision that had come out of a different circuit that was stating that truth in sentencing did not apply to those who were under 18. And that was one of the issues that was appealed. That was every single appellate issue was determined by the appellate attorney, and then the others were all issues that were discussed during the resentencing that the judge had said should be decided on appeal. And that included whether buffer applied in this instance, whether or not they believed that the youthful parole law was retroactive at the time, and whether or not that made it so that the Miller and Buffer line of decisions did not apply to Mr. Hickson.
Okay. And that was all denied in 23?
It was all denied, yes. Yes.
Okay. Okay. We don't have anything submitted to us from the disciplinary record for while you were in Champaign County. Mr. Hickson, did you have any disciplinary issues whatsoever while in Champaign County?
Yes, sir. I just had one for my trade. They was passing out the trays to us, and one of the inmates walked past and bumped me, and the tray fell out of my hand. And they actually just wrote me up for the mess that was on the floor that I had to clean up. That was it, though.
What was the ticket that was issued?
They didn't have specific charges. It just stated that I made a mess on the floor and I needed to clean it up. The punishment was just going out, getting the mop and broom and cleaning up the tray that fell.
Okay, so no actual disciplinary actions?
No, sir.
Okay. We've talked a little bit about the fact that you did have a number of tickets leading up to 2019, and then upon your return, you did have 2 just last year in 2024. I recognize that one of them is pretty clear that it was foul language use, but I wonder if you could give me more information. I know you gave a version in your petition, but why would this staff member have felt harassed by your actions, do you think? What was going on?
I was a teacher aide. I'm sorry.
Go ahead. Thank you.
I was a teacher aide. I've been up there for some time. My teacher was sick. She was crying profoundly. And when she got back, I asked her, was everything all right? And she informed me that her daughter was sick. I asked her, I told her that the art room downstairs does art, and we can make something for her daughter to make her feel better. She told me that would be okay. Her daughter loves unicorns and rainbows. I went downstairs to the art room and had them to make a poster that said "Get well soon" with unicorns and rainbows on it. I gave it to the teacher. The next day, the staff seen it in her class and asked her who gave it to her. And she told him exactly what happened. And he told her that she couldn't do that and that a ticket had to be issued. I apologized and let them know that that was not my intentions. It was just a mere gesture of a get well soon. And the warden noticed it. He called me for a meeting, and he went over everything. And upon further review, he restored me back into grade, A grade from C grade because of that ticket. He understood that it was just a good gesture taken back.
Okay. Do you remember reading the ticket or what the basis was argued for the harassment piece of it?
Yes, sir. It said exactly what I just said, sir.
Okay, just that she felt harassed by the gift?
Yes, sir.
Okay. I did have a question about your version of events, and the reason is we essentially have three versions that are given within both this petition, the forensic psychological exam, and then your testimony and the resentencing. And the reason I bring it up is within the petition, you state that you were selling the drugs that night in order to make money for a place to stay, that you had shot at the individual and then ultimately shot him in the leg, attempting to take the wallet. In the forensic exam, you do again state that you were selling the drugs to make money for a place to stay, but that you were unaware that you had even shot him, I guess made contact twice but that essentially you knew that you shot him once. In your testimony in the resentencing hearing, however, you basically state that you were selling drugs not for money for a place to stay, but selling drugs in order to buy more drugs. And actually state in that record that you initially shot him in the leg on purpose, hoping that he would let go of the wallet. And then when that didn't work, you then shot him in the arm, hoping that he would let go. I'd like for you to explain, I get that there are basically three versions of the same story, but why the discrepancies in such a short period of time?
I have no recollection of saying I shot in the leg to let go of the wallet. I've never shied away from telling my story. The story was when I've tried to sell the drugs, it was to buy drugs to find a place to stay. Because of the friends that I was staying with, I would give them alcohol and drugs just to have a place to stay over their place. That was the purpose of selling the drugs. The money that I was getting from the drugs was actually going to buy alcohol and marijuana.
Okay. For board members who are curious where that last piece is coming up from, it's from the transcript, page 130 to 132, roughly. I don't think I've got any other questions at this time. Thank you.
Julie, do you have another question?
I do. There was also a reference in the resentencing hearing that at the initial trial, there may have been some testimony that this was actually motivated by a rivalry, that there had been some prior interactions with the individual that was killed. Can you illuminate that at all in terms of whether you knew the individual or whether there had been any past conflicts, or if this was, I welcome any additional information.
No, ma'am. I never knew the individual. That was the narrative that was in my previous trial. The person that I gave the murder weapon to, I never told them exactly what happened. I told them that I was shooting at some rival gang members because I didn't want them to know what happened. That was the statement I gave in 1999.
I appreciate that. That does explain at least where that discrepancy came from. Thank you.
Yes, ma'am.
Any other questions from board members? The only question I have is, you got your GED in 2017, and you've taken anger management and drug awareness programs, and it said you were enrolled in Northwestern University program. What are you doing with Northwestern?
I'm on a course to get my bachelor's in social science.
How many credit hours have you gotten so far?
I'm not for sure about the hours, but I've completed 7 classes.
Okay. Are those
as of my latest? Yes, sir. My latest transcript, I just received. My grade point average now is 3.7, and I'm on my way to completing 7 classes. I don't know exactly about the credit hours, though.
Okay. Are those the only 2 classes? I mean, anger management and drug awareness. Have you taken any other classes while you've been in ag corrections?
Yeah. Yes, sir. Yes. Yes, sir. I took Thinking for a Change. I took that in Pinckneyville. Aim Higher. Of course, drug awareness, substance abuse, dual diagnosis, creative writing, masculinity of justice from DePaul University, transformation of justice from Benedictine University, and critical thinking in Danville Correctional Center.
Okay, thank you. I have no further questions. Does the board have any further questions for either Mr. Hickson or the witnesses at this point? Seeing none, Mr. Coates, do you have anything that you want to do at this time?
Chair, I'll make a motion.
Okay, go ahead and make your motion.
Right. First, I do want to acknowledge and recognize the victims of this offense. Even without opposition, I recognize the pain and the forever impact the loss of Mr. Jerry Bringer would have on the community as well as his family. Mr. Hickson has made a positive transformation since coming into incarceration. Speaking first to his institutional adjustment, I would not say he's had a minimal disciplinary ticket history, but rather a moderate disciplinary ticket history. He has certainly made some mistakes along his journey to growing as a person. I felt it was a positive that he had only had one ticket of actual violence, which was for fighting in 2002. In the past 5 years, he has received just 2 tickets. During his interview, he was able to clearly articulate the trauma he received as a youth, how that manifested into poor thinking and decision making. He was remorseful, he takes accountability, and recognized the extreme harm he caused to the Bringer family and the community. Given this, I do confidently feel he has the ability to conform to reasonable conditions of parole and that his release would not have a substantially adverse effect on institutional discipline. Since gaining access to programming and education in 2014, Mr. Hickson has remained committed to rehabilitating himself through education and programming, earning his GED, his many certificates of programming, working towards his bachelor's degree, and the positive impact he has had on his peers. I was profoundly moved by the impact he had on the Northwestern University prison education program and their community. His growth as a person from who he was at 17 years old to who he is now, I feel is meaningful. From being someone who at one time was heavily influenced by his environment negatively, I do feel he is now a person setting the tone in his environment and making a positive impact on each person around him. After serving 25 years, combined with his impactful programming, education, also combined with his strong support of wraparound services upon release, and that includes St. Leonard's, Precious Bloods, and Northwestern University, I do feel parole release would not deprecate the seriousness of the offense or promote a disrespect for the law. So therefore, my motion is to grant parole today.
Motion's been made. Do we have a second? Second by Mr. Ronas. Ellen, please take the roll.
Mr. Coates,
Yes.
Ms. Globoker,
Yes.
Mr. Grubbs,
No.
Mr. Heaton,
Yes.
Ms. Tarones,
Yes.
Mr. Boland,
No.
and Ms. Tyson.
Yes.
Mr. Tupy,
No.
The vote is 5-3.
By a vote of 5-3, the motion fails for granting parole.
No, under the youthful parole, it's a majority of the members present.
What?
Under the youthful parole law, it is by a vote of majority of members present.
No, the vote is majority of those appointed. There's currently 10 members of the board, so you need 6 votes. Well, we lost golf.
Youthful parole is under a different part of the
Delgado's
statute.
still on the board until April 30th.
We have the role. We can certainly consult the law to ensure it's applied properly.
We'll continue. Thank you. It is the youthful parole. I'm pulling it right now.
Mr. Hickson, please be patient with us. We're going to figure this out. Thank you.
At this point, we'll take a short break, everybody, take 5 minutes, and then we'll call the next case.
It's, I have 730 ILCS. Is that what you, 5/3?
You got a printout of those, and at this point, we'll have to take a look at the law and review it. But for
Thank you.
parole, it's
I will.
always been a member, all the members appointed. But let me
No,
take.
I understand for traditional and C numbers, it was under a different statute for youthful. I'll get you a copy right now.
Thank you.
I think we are.
Vote means whether or not it grants parole or denies parole based upon a legal analysis, which I will have with the attorney. Oh. Is he? Can he? Okay. We're going to call the next case with regard to Mr. Hickson. There has been a vote. The vote is 5-3 that we're going to determine with legal counsel what that vote means, and we will notify Mr. Hickson's attorney after I talk with legal counsel from Lieutenant Governor's office, and we will notify you what that vote means, whether it grants parole or denies parole. But we'll look it up and let you know. But so we're going to move on to the next case and do our legal analysis later. Mr. Hickson, can you hear this? Hello? Mr. Hickson? Can you hear us? Mr. Hickson? Mr. Hickson, can you hear us?
Falonzo? Mr. Hickson Falonzo?
Okay, let him know. Ellen, do you want to call the next case?
Next case is Antonio Woodson.
Mr. Woodson, can you hear us? Can you hear us, Mr. Woodson?
Mr. Woodson, can you hear us?
Mr. Woodson?
They were asking.
Can you hear us? Mr. Woodson, can you hear us?
He's unmuted. Yeah. I mean, your video's open.
Hey.
I'm not
are
sure
you-
what. I think it might be on their end.
We can hear her, but we can't. Can you hear us?
Yeah.
Okay.
No, I think they were tagging one another.
Okay.
Mr. Woodson, can you hear us now?
And it worked earlier when they checked in.
So you can hear us at this point, correct? No.
I can hear you guys on it. But you can't hear them. Yeah. Yeah, we can't hear that. We can't hear you, but you can hear me.
Yes.
Okay, there we go. Now we can hear you.
Okay. So you can hear us now.
Yes, thank you.
All right. Let's proceed to the next case. Have the witnesses been sworn at this point? All right. Call the next case.
Next case is Antonio Woodson.
Okay. Ms. Glovoker, this is your case. Proceed.
All right, thank you. Good morning, Mr. Woodson. Just to explain the layout of today, I'll be providing my presentation. We will briefly go into closed session, and that's to discuss any matters such as juvenile record, medical or mental health records, and then when we come back, we'll have the opportunity to hear from your attorneys as well as yourself.
Okay.
Mr. Woodson is currently incarcerated at Kiwani Life Skills Reentry Center. That was a recent update as of early this month. He was interviewed on January 16th, 2025 by myself via WebEx when he was at Pinckneyville. The interview began at 9:20 a.m. and ended at 10:40 a.m. Also present were Mr. Woodson's two attorneys, Abigail Elmer and Rachel Sansonetti, his mother, Frances Woodson, and his maternal grandmother, Everline Hampton. The attorneys indicated that a mitigation specialist had also desired to attend but had been unable at that time. Mr. Woodson is 40 years old and has been incarcerated approximately 22 years. He was 17 at the time he committed the offense of first-degree murder and vehicular hijacking. He presented with a calm and relaxed demeanor and gave an impression of candor throughout our interview. Regarding statement of facts, on the night of the offense, January 11th, 2003, Mr. Woodson, then 17 years old, was staying at his grandmother's house near Garfield Park in Chicago. He attended a party with three co-defendants who ranged in age from 14 to 17, and they decided to walk to the park to steal a car. Mr. Woodson had a loaded handgun with him, which he showed to the others before they got to the park. Victim Jimmy Patton, age 46, was in the park smoking cigarettes and drinking beer with two of his friends. They were seated in one of his friend's cars next to Mr. Patton's running vehicle. The co-defendants approached the car that was occupied by Mr. Patton and his friends. One of the co-defendants initiated contact under the guise of asking for a cigarette and then said something to the effect of, "Where's my uncle with this car?" referring to the running car. Mr. Patton responded something to the effect of, "You don't want no effing cigarette, you're on some BS." He reached into the passenger side of his own car to turn it off, and he placed the keys in his pocket. A co-defendant asked Mr. Woodson something to the effect of, "You got him," or "Do you got me?" meaning essentially, "Do you have my back?" Mr. Woodson drew the firearm and pulled the trigger, but the gun only clicked. He cocked the gun and fired again. The victim sustained 2 gunshot wounds, one to his hand and another to his chest, and fell to the ground. A co-defendant retrieved the keys from the victim's pockets and took off at a high rate of speed. The car was ditched a few blocks away. Mr. Woodson was arrested several months later on September 6, 2003 on an unrelated battery case. The next day, he found out that he was wanted for questioning in this murder, and his mom and grandparents escorted him to the police department where he ultimately confessed. There were some disputed facts to this case. The initial statement of facts indicated that the victim was, quote, shot twice. However, it does appear that the same bullet may have traveled through the victim's hand and into his chest, resulting in the 2 bullet wounds. In past proceedings, Mr. Woodson has referred to the shooting as an accident. He holds that he intended to shoot past the victim rather than shoot him. In his recollection, a co-defendant was wrestling with the victim to obtain the keys, which is when he tried to fire a shot to get them to stop. And then, quote, "It was like he jumped my way. That's when I cocked it and tried to shoot past him." Other versions of the offense that appear in documents vary only slightly, such as indicating whether one or two of his co-defendants were wrestling with the victim over the keys when the weapon was drawn. According to the appellate court record, he initially admitted to being with the co-defendants on the evening of the murder, but claimed that he ran away before one of the co-defendants committed the final offense. Once he was presented with the video-recorded statements of his co-defendants, he admitted to the shooting, and he has taken accountability for the murder since that time. He was convicted by a jury and originally sentenced to 50 years for the murder and 10 years for the vehicular hijacking. In 2017, he filed a pro se post-conviction petition challenging the constitutionality of his de facto life sentence. On a subsequent appeal, he was granted a resentencing, and on July 1st, 2022, he was resentenced to 30 years for the murder and 11 years for the hijacking, for a total sentence of 41 years. The court then further reduced that sentence by a year, indicating that the increase in his hijacking sentence was contrary to law. More recently, the appellate court found that the resentencing court had abused its discretion in failing to adequately consider mitigating factors as set forth by the law. They noted that the judge had failed to mention significant cognitive deficits. The appellate court also pointed to the contrast between what they saw as overwhelming evidence of Mr. Woodson's rehabilitation, including his notable record within IDOC, with the resentencing judge's statements that, quote, "I'm not sure how doing well in prison goes to rehabilitation or not," and that Mr. Woodson's prison record counted for, quote, "half a mark," and that, quote, "none of that mitigates a murder." The appellate court exercised their authority to further adjust his sentence to where it presently stands at 25 years for the murder and additional 5 years for the vehicular hijacking, with a projected release date currently standing at January 9th, 2029, if not granted release by this board. It appears that one co-defendant in this case was sentenced to 17 years for the aggravated vehicular hijacking, and the status of the other two co-defendants is unknown. Regarding his statements to the offense, in the interview with this board, Mr. Woodson took full responsibility for participating in the carjacking and firing the gun, resulting in the loss of Mr. Patton's life. He states that at the time, he was presenting himself for concern over how others would view him. Even after the shooting, he was concerned that those around him would judge him if he changed how he acted, but he stated, quote, "In his heart and soul that night, that never should have happened. That man never should have lost his life, especially for his prized possessions that he worked so hard for." He stated that when he returned to his grandmother's house after the offense, he was shaken and, quote, "immediately fired up a blunt and started drinking again." He said that he had just shot someone not out of bravado, but rather because his mind was racing from what had happened, and he, quote, "just wanted to get up out of there," so he went to his aunt's house. When asked what he would share with the victim's family if given the chance, he stated, quote, "Sorry is not enough because I caused their family heartache and pain. I continue to pray for healing for them. I also ask for forgiveness, but if those pleas are not heard, I understand that because one of their family's members was taken from them." He stated that he remains deeply sorry because, in his words, quote, "that night that man never should have lost his life." Regarding criminal history, he was 17 at the time of the offense. He has no other criminal convictions. He does have one arrest as an adult at the age of 18 for a misdemeanor battery. In September of 2003, this was the day prior to him being brought in for questioning on the present offense. In that case, a man had emerged from a car and confronted Mr. Woodson with a knife, and Mr. Woodson had punched him. The victim initially alleged that Mr. Woodson had attempted to carjack him, but he did recant, and it does appear on his record as a misdemeanor battery arrest, not as a conviction. Any record of juvenile arrests will be discussed in closed session. Regarding his background and institutional adjustment, his mother came from a strict upbringing in the suburbs, whereas his biological father was considered a leader of a street organization and had been in and out of prison. When Mr. Woodson was 12, his mother was diagnosed with brain tumors that caused a host of health issues, including numerous strokes, and resulted in nearly a year of hospitalization. During that time, Mr. Woodson and his siblings were split up among households within their family. He moved frequently among relatives or stayed with a friend, resulting in a lack of stability and consistent supervision. Letters of support from those familiar with his childhood recall this as the time in which his behavior changed and he started to fall in with the wrong crowd. He was involved in the Black Disciples, which further placed him around negative peer influences. I will note that there's no indication that Mr. Woodson was involved in gang conflicts or gang-related violence during adolescence. He describes primarily smoking and drinking during that time, nor does it appear that he has been gang-affiliated since his incarceration. Regarding schooling, he was in special education from first grade up until he left school in 10th grade, and he struggled academically. He did briefly study welding in the Job Corps. After arrest, he took high school classes in the county jail, but dropped out due to recurring lockdowns. He began pursuing classes again in 2017 and earned his high school diploma in September 2023 from Kingsword Academy. He's also taken a class on the impact of crime on victims and earned several certificates from Set Free Ministries. He's a certified barber, a credential that involved more than 1,500 hours of training. He's been working within IDOC since at least 2012 with positions including employee dining, barbershop, painter, tunnel crew, and inmate kitchen. When he was at Cook County for resentencing, he worked as a barber and a sanitation specialist. Since transferring back to IDOC custody, he has been listed as a specialist in the inmate commissary and a barber in Pinckneyville. Early in April 2025, he was then transferred to Kewanee, where he resides at the time of this hearing. He's received only 5 tickets in the entirety of his custody in IDOC, 2 of which resulted in a period of segregation. His first ticket in 2009 was for yelling that he was able to navigate Menard as a young man so cleanly without signs of gang involvement. While I couldn't locate his spin assessment in the file, there was an evaluation by a Dr. Robert Hanlon that was available for our review that assessed him to be a low risk for reoffending. His file also contains several letters of support from employees of both Cook County Department of Corrections and Illinois Department of Corrections, praising his demeanor, work ethic, and positive attitude. 2 employees of Cook County Department of Corrections testified favorably to his character at resentencing. One such employee with 18 years experience as a correctional officer indicated this was only his second time testifying on behalf of an individual in custody, and when asked whether he had seen any other, quote, inmate as trustworthy and hardworking and well-behaved as Mr. Woodson, he responded, quote, absolutely not. In a recent supplement to Mr. Woodson's petition, 2 supervisors from Pinckneyville's commissary submitted letters of support. They described him as a leader who had taken the initiative to mentor new employees and as, quote, a self-motivated team player, organized, respectful, and detail-oriented who brings positivity to the workplace. I admit to being surprised by the minimal number of tickets he had received for having been incarcerated as such a young man. When I asked him what accounted for this positive institutional history, he stated that prior to his incarceration, he was maintaining a persona for those around him. Once he was in custody, he decided to change for himself. He changed his social circle and leaned into meditation and prayer, which provided him with greater clarity of thought. And he further credits finding his love for cutting hair as further grounding him. Any history of mental or medical health records will be discussed in closed session. Regarding his parole plan, he has received confirmation of acceptance to St. Leonard Ministries. His attorney indicates that they now have a wait list, but that St. Leonard has indicated they anticipate they could place him within weeks of release. He also has standing offers to reside with his mother, grandmother, and others in the interim if St. Leonard would be unable to accommodate him. His long-term goal is to open his own barber shop, but he does understand there are steps to attaining that, and he's open to any opportunity that would allow him to financially establish himself. His uncle does have a barber shop, and so his first preference is to work there, but he also has friends and family who are willing to help him pursue a variety of career paths, and it was in evidence in their statements of support that they could provide opportunities in landscaping, trucking, working in a steel mill, or working in retail or fast food. Mr. Woodson has expressed a desire to do one-on-one mentorship with kids who are situated similarly to his past self. He expressed the importance of removing youth from their negative environment to see their true capacity and the importance of individualized attention and encouragement for youth. The board was presented with more than 20 letters of support and character references from friends, family, and correctional professionals, as well as the mitigation specialists, some of which had also been submitted for consideration at his resentencing. Many of the authors credit Mr. Woodson as a positive influence in their lives, and there were also accounts of him mentoring young men to stay away from the street life and pursue positive goals. His support system has offered to provide housing, occupational opportunities, encouragement, and accountability should Mr. Woodson be released. There are no known factors that would prevent his release. The board is unaware of any relevant healthcare or treatment needs that would affect his placement. There is opposition that was available to us from the Cook County State's Attorney. Any other opposition would be discussed in closed session. As Mr. Woodson is newly eligible for parole pursuant to his resentencing after the adoption of the Youthful Parole Act, there is no en banc history to consider. And so with that, if there are no questions immediately, I would move to go into closed session.
Okay. Motion's been made and to go into closed session and seconded. Those in favor respond by voting aye. Aye.
Aye.
Okay. Ladies and gentlemen, I'd ask you to leave momentarily, and then we'll call you back in. Take all your belongings with you, please. Thank you.
If you're speaking, I can't hear you.
All right, we just came back into session. I'm open to questions from the board and happy to turn things over to your attorney as well as you, Mr. Woodson.
All right.
Good morning. My name is Rachel Sansonetti.
We need to get you guys sweared in.
Oh, yes.
If you guys can please stand. Mr. Woodson, can you please raise your right hand?
Do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning. My name is Rachel Sansonetti. Beside me is Abigail Elmer, and we are pro bono counsel for Antonio Woodson. I would like to start by extending our deepest sympathies to the Patton family. This is a tragic case where a husband, a son, and a father lost his life. For the last 22 years, Antonio has lived with the guilt of taking another man's life. He's deeply remorseful for his actions, and if he can go back and make a different choice, he would. But he cannot change the past. He can only do better and be better moving forward. And Antonio has done all he can in the IDOC to be rehabilitated. Over the last approximately 22 years, he has gained a good reputation in the Department of Corrections. He is compliant with rules and orders. As was already mentioned, he has an almost spotless disciplinary record, having only received 5 tickets, none of which are violent. Antonio is who the legislature envisioned when it created youthful parole, as he has been rehabilitated and has completed everything that the IDOC has to offer for rehabilitation. And I want to note that this is his only opportunity to appear before this board for parole, as his next opportunity will be in 2035, and his out date is currently 2029. Antonio has a robust support system, including friends and family. His mom and his grandmother are present today, and I would ask them both to stand. Thank you. Several people have written support letters that are attached to Antonio's initial petition and his supplemental petition, including a letter from a licensed clinical social worker, Amanda Myers, who worked with Antonio during his resentencing in 2022. But she has remained in contact with him because she views him as, quote, a lovely person and someone who deserves all the support that he can get. He also has support from correctional officers who believe Antonio is ready to reenter society. Antonio applied to Kewanee in early February and was accepted and transferred within only 2 months. Our understanding is that such a quick transfer is extraordinarily rare, but it's not surprising considering the amount of support he has from prison and jail staff. At his resentencing in 2022, several IDOC and county jail employees testified on Antonio's behalf. The former IDOC director testified that Antonio is contrite, remorseful, accepts responsibility for his actions. He has role models, future goals, and a comprehensive aftercare plan. Cook County Department of Corrections employee Patricia Brown Conley testified that Antonio is a, quote, model person and a great guy. And in her 14-year career, Conley has only ever testified on Antonio's behalf. No other inmate she felt was deserving of her testimony. Cook County Department of Corrections Officer Henry Peaks also testified that he had not met a more trustworthy, well-behaved, and hardworking inmate than Antonio. And he said, quote, "Antonio is one of the guys that we don't have to worry about having to discipline or constantly say things to him over and over again." And in his 18 years of work, Officer Peaks only testified on behalf of one other inmate. 2 supply supervisors at the Pinckneyville Commissary also wrote letters of support for Antonio. Andrea Presley says Antonio, quote, "brings positivity to the workplace and has been a great asset to the commissary. She believes parole would be a great opportunity for him to start his new positive beginning in society." And Amy Wanick explains that Antonio took a leadership role in the commissary, jumped in when he was needed, even without being asked, and trained new workers. She ends her letter by saying, and this is a quote, "I believe parole would be a very good thing for Mr. Woodson. He has my vote. I am confident he will be an asset to the community. We hope this board agrees with the staff from IDOC and Cook County Detention Center who have met Antonio, have spent time with him, and see his character, and believe he should be on the outside and contributing to society." Thank you.
Okay. Do we want to let Mr. Woodson testify at this point?
Yeah, Mr. Woodson, if there is any statement you'd like to make to the board, you're more than welcome.
Okay. Thank you. Greetings. My name is Antonio Woodson, and I'm sitting here in front of you today for a crime that I committed back in 2003 when I agreed to tag along with a group of friends to go steal a car. Never in my mind I would have thought I would have shot and killed a man over his own prized possession. In no shape or form that night supposed to have ended with a man losing his life. That night not only changed my life and the lives of my family, but most importantly, it had changed the lives of the Patton family. And because of it all, this is something that will live within me for the rest of my life. I did not realize that the groups I was hanging in and my sole desire to be in them streets would cause so much pain and hurt. Looking back, I could remember having to fake and act like I had to use the restroom just so my turn could be skipped. Not knowing that I may have been dealing with some insecurity issues with schooling may have pushed me more, I believe, towards the streets, where there I was more accepted, wanted, and most importantly, not judged. Even leading up to my arrest and conviction, I was still trying to ride that coattail of that criminal thinking, all because I was afraid to truly change for the fact I care how I was viewed, how my so-called peers would judge and think of me. However, that all started to slowly change when I made a very conscious decision in 2009 after continuous prayer and guidance to adjust my lifestyle. Because of my past, it helped me to become mindful of who I associate with and the company that I keep. I've truly asked God for forgiveness, and I know I've been blessed through him, because here I am before you also today, a responsible, respectful, and productive individual who has a sense of direction, purpose, and passion. However, in the same breath as he sees fit, with my constant prayer that the Patton family hears my pleas for forgiveness as well. But in the same sense, if my pleas went unanswered or a simple no was shouted out in the far distance, then I will totally understand. More so, I will continue my prayers for their healing, because there is no one else to blame but my own, because it was my own foolishness and outright stupidity that caused their heartache and pain. And for it all, I truly apologize for my selfless and reckless acts. As I got further into my incarceration, my views on how I see things and other individuals became more different. And when my surroundings started evolving and my mind became more clearer, I started making better choices for myself, and which led me to start caring less of who, what, and how other individuals thought about or judged me in any kind of way. That's when I started seeing the progression of my growth. More so when I started working, I worked as hard as I could to try to become the best working individual in whatever I do or did. I truly want to take pride in my workspace. And when that hard work started spilling over into my everyday life, I knew then I was becoming into the best version of myself. I just knew that I had to continue to work as hard and stay productive because I know that it's easy to lose focus and get I know it's easy to lose focus and get off course when distracted, especially when there's negativity as well as temptation surround you. But because I became so driven and dedicated, I was able to achieve my high school diploma and graduate from Larry's Barber College, becoming a master barber in my craft. I believe because of my incarceration for these past 2 decades that I've really come into being this strong individual now with that sense of direction, purpose, and passion that can contribute to our society. Given the opportunity, yes, I am willingly and ready to utilize my truth of wrongdoings and to bring a positivity, strength, and a focused attitude to our youth. I want my cause to be helping the community instead of being the problem and hurting the community. Thank you for your time.
Thank you. You want to go? You have anything else you want to say, Dr. Kloboker?
I'm open thanks to questions for myself, Mr. Woodson, or his attorneys.
What, at the most recent resentencing, what position did you take regarding what the sentence should be?
At the most recent resentencing, we were not his attorneys then, but the court at the resentencing resentenced him to 30 years for the murder plus 10 for the hijacking, for the vehicular hijacking, and then the appellate court reduced that to a total of 30 years, 25 for murder and 5 for the vehicular hijacking, finding that the sentencing court was too focused on retribution in its sentence.
Thank you.
Mr. Bolin.
Mr. Woodson, let me first, I do want to commend you for the work that you've been putting forth toward your rehabilitation, and congratulate you on getting into Kiwani. Obviously, that's a positive step as well. I did have one question. If I'm reading both your version of the offense and what I gather from the statement of facts, is that you pulled the trigger multiple times. Is that correct?
No, I only pulled it one time. But it says that in my records that it was 2 bullet wounds, which the bullet went through his hand and hit his chest.
Okay. And so you're saying there were 2 bullet wounds, but you're saying you did not pull the trigger more than once?
Yes, I did not pull the trigger more than once.
Okay, was somebody else there found to be shooting a gun that you're aware of?
No.
Okay. I think that's all my questions. I was going to ask why you felt the need to pull the trigger twice, but I understand that's not your testimony today, so thank you.
You're welcome.
I will state that was one of the points of inconsistency where the reference to the victim being shot twice did appear to be a reference to the 2 bullet wounds, and I couldn't find any reference that that more than 1 bullet had been fired that day.
I'm not sure Mr. Woodson understood the question. Did you pull the trigger and it not fire, and then pull a second time?
Yes, I tried. Okay. The first time, when I pulled the trigger, it did not fire. But then, when I felt or thought and panicked that the victim launched at me, then I tried to shoot past him to get him to stop. But only 1 shot was fired.
That's what I thought. You misunderstood the question. Mr. Rowland, does that raise any issues with you?
I think he clarified there what I would have asked as to why he felt the reason to pull the trigger again after it didn't fire.
Oh, okay, I'm sorry.
Do we have opposition in this case? Please identify yourself for the record and then list your opposition.
Yes, good morning. My name is Courtney Quam, and I am a Cook County Assistant State's Attorney. The Cook County State's Attorney's Office does oppose the granting of parole in this case. It is the state's position, that granting parole in this case at this time would deprecate the seriousness of the offense as well as promote disrespect for the law. Mr. Woodson's sentence was modified by the appellate court, as we've previously discussed today, in January of this year. And in consideration of the fact that he was 17 years old at the time he shot and killed Jimmy Patton, they also considered his institutional adjustment, his rehabilitative efforts, his expressions of remorse, everything that you, the board, are reviewing today. They then sentenced Mr. Woodson to 30 years imprisonment. 30 years imprisonment is the amount of time that the appellate court concluded was appropriate in this case. Furthermore, Mr. Woodson's age and lack of maturity at the time that he shot and killed Mr. Patton are certainly relevant and provide context to the crime, but those factors do not absolve, justify, or excuse his choice to shoot and kill Jimmy Patton. This was not an accident. This did not just happen. Mr. Woodson and his companions planned to steal a car, and Mr. Woodson brought a gun. He then fired the first time, and when it did not go off, he fired again, killing Mr. Patton. And now today, he's asserting that he fired the second time because Mr. Patton was lunging at him, when Mr. Patton was sitting in a car with his friends, minding his own business, and Mr. Woodson and his companions targeted him. Mr. Woodson pulled the trigger before they could even actually tell Mr. Patton what they wanted from him or give him a real chance to even comply. So the people are not convinced at this time that Mr. Woodson has demonstrated acceptance and full insight into this violent crime that he committed. And finally, Jimmy Patton's son, who's named after his father, also strongly opposes parole. Thank you.
Any questions for either the state's attorney's office or Mr. Woodson and his attorneys?
I do for the state's attorney. Is there any question in the record? It appears that Mr. Patton was innocently there with friends in the vehicle, and it sounds like he had, from what I had read, gotten out of the vehicle to turn off his own and may have been struggling with the co-offenders. Is that accurate to the record, or is that a misunderstanding?
I'm sorry, can you, I'm having a little bit of trouble
sorry,
hearing
sure.
you. I'm sorry.
So my understanding of the record of what happened in the incident was that Mr. Patton was indeed initially innocently in the car, I mean, clearly innocent throughout, an innocent victim in this situation, but had been sitting in his friend's vehicle, had gotten out of that vehicle to turn off his own, and had placed the key in his pocket, and that there may have been some kind of a struggle with the co-defendants. Does that sound accurate to the record, or are you aware of?
No, it is not the state's position that there was a struggle between Mr. Patton and Mr. Woodson.
No, that's correct. My understanding was the co-offenders, was my understanding from reading the record.
I'm not sure I understand exactly.
Okay, so what I saw, I believe even in the statement of facts, was that that the co-offenders were struggling with the victim and said something to the effect of "you got me" or "you got my back," and that's when he fired. So I understand your contention that the victim was not struggling with Mr. Woodson directly in the record, but it sounds like there may have been something with the co-offenders. Is that accurate?
I couldn't say right now.
Okay, that's fair. All right, I just wanted to make sure I have some understanding. Okay, other questions, or otherwise we can ask for a response.
Are you ready for a response? Okay.
I think so.
Thank you. Today, this board has heard from Antonio himself. In his almost 22 years of prison, he has shown acceptance of the harm that he caused to Jimmy Patton and his family. He has shown remorse for what he did, and he has shown accountability for his actions. In his time in the Illinois Department of Corrections, he has been a model prisoner. In the almost 22 years he's been there, he's received only 5 tickets, all of them for nonviolent offenses. And you've heard from Department of Corrections employees that they are impressed that he was able to keep the number that low. 2 directives of this board are to, which the state mentioned, are to promote the respect for the law and to not take action that would have adverse effects on institutional discipline. Granting Antonio parole today would promote these objectives. Antonio's release would show other youthful offenders that if they atone for their actions and if they improve themselves while in IDOC, that this board could grant them a second chance. This board has a different role than the sentencing and appellate court. The first appellate court that considered Antonio's resentencing found that his 60-year sentence was unconstitutional as applied to him because of his youth. Then the appellate court changed his resentencing because of errors. It saw that the resentencing court was too focused on retribution. The sentencing court did give that sentence with the knowledge that Antonio, a youthful offender, would be before this board and would have a chance at youthful parole after 20 years. The appellate court was concentrated on fixing past errors. You have the chance today to look at who Antonio is today, not who he was 22 years ago when he was 17 years old. He is a man with familial support, one with the support of numerous IDOC correctional officers and employees. He has the support of St. Leonard's, where he has been accepted to live after any release. And he has a reentry plan and multiple job offers from family and friends. We ask that this board consider who Antonio is today and all that he has done to improve himself while in the Department of Corrections and grant Antonio parole.
And excuse me, if I could just add regarding the resentencing, where the appellate court reduced the trial court sentence from 40 years to 30. The court did not do a full analysis about why they were reducing Antonio's sentence. So they did not go through like the circuit court might have and said, you know, because of Antonio's character and because of the offense, and, you know, they didn't go through a whole analysis and saying, we believe this is an appropriate sentence because of Antonio and the offense. Rather, they based the resentencing numbers on a previous case, McKinley, where before the court they had statistical averages that showed that youthful offenders who are resentenced for a murder after an unconstitutional sentence has been overturned, that the average year for a murder is 25 years. So I just want to be clear that although he did get a sentence reduction in June, it was not based on the court's an individual analysis of Antonio. It was just a number, a statistical number that the court felt was appropriate. And this board has the opportunity to look at Antonio's rehabilitation, look at his character, and grant him release. So, thank you.
Do you have anything else, Dr. Globoker? Any questions?
I don't. I was just looking back at the court record. I do want to make very clear there's no question that this was an innocent victim involved. What I'm seeing from the testimony was that the victim had gotten out of the car. When he started to realize things were awry, one of the co-defendants had said something to the effect of, "You got me," or "You got my back." The other individuals realized something was happening and had taken off, and at that point, Mr. Woodson had shot Mr. Patton. So the specifics, you know, it's what I have in front of me. Sorry, Mr. Boland. Yeah.
Yeah, I just, I think I had a follow-up question for counsel. Remind me the basis of the appeal. It was, my understanding is that the appeal was based on the mitigating factors not being taken seriously enough. Is that correct?
Yes.
Okay. I think just for the point of deliberation, my concern here is that if the point of the appeal was that the mitigation that was on the table was not taken seriously enough, the large majority of what's been presented to us was presented at the initial resentencing. It obviously was taken seriously at the secondary appeal and acted upon. He has done a lot of good things, but he's also the beneficiary of 2 resentences that took all of that into consideration, and I do have some concern about disrupting something that was taken that seriously twice now, and just recently was resentenced this year down to functionally 26 years. I will also note that his transfer to Kiwani actually presents as opportunities to get more reentry services and community integration access as well.
Could I respond? So he did appeal twice. The first sentence was unconstitutional, so I would not say that's a benefit. It was a correction of a constitutional violation, which never should have happened in the first place. He never should have gotten the original 60 years. That was a legally invalid sentence. And then his second sentence, or his second appeal, just because the underlying arguments presented is that the court didn't take into consideration proper mitigation, does not mean that the circuit court did take into consideration. They didn't do a full analysis of the mitigation. And so it's just a little bit of a confusing nuance where what attorneys might present to the circuit court isn't exactly what the circuit court winds up doing. So I would not, again, I would characterize this most recent resentencing as correcting a wrong done by the circuit court, and not, again, something that the appellate court necessarily thought that this is exactly the appropriate sentence. It was based on a random, an average based on statistics. And I would also, I believe the state misspoke. He was not resentenced in January of this year. He was resentenced in June of last year. I'm sorry, the appellate court decision came down in June of last year. The resentencing was in 2022.
But didn't the appellate court review the resentencing and issue an opinion in January of this year?
So what happened most recently is that the state appealed the appellate court's decision to the Illinois Supreme Court, and the Illinois Supreme Court denied that appeal. And so the sentence became final when the Illinois Supreme Court denied the state's appeal, but the appellate decision did come out in June of 2024, and that's when they issued their opinion.
If I could briefly speak, the reason I said January is because according to that final appeal that came down, which is number 1-22-1172, on it, it is file stamped January 8th, 2025.
So that's when it became finalized.
Yes, that's when it was filed, and that's why I used that date.
Okay. Okay. Any further questions from the board? Do you have any further issues to address before we take our vote?
No. No, thank you.
Okay, thank you. Dr. Globoker?
Thank you. On January 11th, 2003, Mr. Patton's family was forever changed by Mr. Patton's senseless murder. On that day, Mr. Woodson, at the age of 17, caused irreparable harm to Mr. Patton's family. Mr. Woodson has appropriately served more than 2 decades of his life behind bars as a consequence of those actions. For most of Mr. Woodson's sentence, he had every reason to believe that he would be spending 60 years in prison for his crime. and yet his record does stand in sharp contrast to that of most individuals who are incarcerated at an age of immaturity with little hope for release. From the start of his incarceration, he's demonstrated a remarkable level of personal accountability, earning the respect and trust of those around him in the process. In evaluating his file, I was particularly attuned to any indicator that his character was anything other than it appeared, but this review led only to the conclusion that he in fact has been the grounded individual that he presents himself to be at this point for more than 2 decades, and based on character letters, appears to have been prior to his period of instability and the actions that he partook in during his adolescence. I can find no reason to doubt that he is sincere in his account, that he experienced immediate remorse for his actions, and that he genuinely does understand the depth of injustice that occurred to Mr. Patton's family at his hand. His demonstration of behavior appears to be thoroughly intrinsically motivated, and with further reassurance of his strong system of support and accountability and his parole plan, I have genuine trust that he would conform to the conditions of release if provided the opportunity. I do think that his release would be expected to be beneficial to institutional discipline, showing that others that hard work and respect for the rules will be recognized. And while no length of sentence can fully reflect the depth of harm that resulted in a loss of life, I do not believe that it would deprecate in this instance, to the extent that individuals of a variety of characters can and do get pulled out of that character in their pursuit of pure acceptance in their youth. In some contexts in our society, that all too often has fatal consequence, as has been the indication here, but that he has in fact demonstrated remarkable insight into these dynamics, remorse, and accountability for his actions. He has expressed interest and has demonstrated a capacity to positively influence others who may be dangerously close to following the path of his own youth. His consistency of character leads me to believe that he would not only be successful, but would be situated to be a stable and positive influence in the lives of contemporary youth who are at risk of losing themselves in the pursuit of pure acceptance in ways that would not only endanger their own lives, but also that of other innocent others. I do believe that he would be an asset to the community, and for that reason, I do motion to grant parole to Mr. Woodson.
Motion's been made.
Ms. Globoker?
Yes.
DOC has, legal from the Lieutenant Governor's office has indicated that the majority of those present at the hearing, a vote to grant parole would grant the parole. It's not a majority of those appointed as in all the other statutes. It's a majority of those present for juvenile hearings only. So knowing that, you should make your decision according to that.
All right. Apologies for that brief interjection, Mr. Woodson. So we were clarifying a procedural matter, as not all board members that are appointed are seated today. And so we needed to clarify for the record how many votes it would take to result in an affirmative release. I had motioned to grant release. Mr. Coates had seconded it, and I believe we're in the midst of taking the roll.
Okay.
Ms. Globoker?
Yes.
Mr. Grubbs?
No.
Mr. Heaton?
No.
Ms. Torrones?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
No.
Mr. Coates?
Yes.
And Mr. Tupy?
No. Motion to grant parole is denied, as the vote is 4-4.
All right, so it would have taken a majority vote of at least 5 out of the 8 seated members to grant parole. The vote was 4-4, so parole was denied in this instance.
Okay, that concludes the hearing. Thank you. As you heard, the legal from Lieutenant Governor's office indicated that it's following the...
I would ask that we recall Mr. Hickson's case.
We're just going to, we've already had the vote, so it's just whatever the legal is. So at this point, according to legal from Lieutenant Governor's office, they say that the vote for granting a parole passed. I'm going to review it, but that's what they say.
Thank you.
Sure. I'm ready to go. You guys ready, or you want to keep going? Quick. He's got to get out of here. He wants to. What? Oh, yeah. Are we ready to begin the next case? All right, Ellen, please call the next case. Allie or Amy?
No, it's okay. The next case is Eddie Pitts. Oh, hold it. It's okay.
Yeah, go ahead for presenting. Go ahead.
Are you sure?
Yeah, you don't have to type while they're presenting.
Right. Oh, hold it. It's okay. It's not a worry.
All right, Mr. Bolin, are you ready for me? Go ahead.
I am, thank you. All right. Eddie Pitts, number L01404, was interviewed in person at Lawrence Correctional Center on February 18th, 2025 at 9 a.m. Mr. Pitts was represented by pro bono counsel Carolyn Clarquist. Mr. Pitts was polite and open to questions, but he also showed some obvious frustration that appears to be rooted in not understanding why the Prisoner Review Board hasn't released him at this time, and I'll go into that later. Mr. Pitts appears to be in good physical health. I might argue above average physical fitness, particularly given his placement in the healthcare unit and his age. Mr. Pitts explained his escalating issues with memory loss at the outset. The interview was not particularly linear. We did bounce around a little bit in subject matter. Ms. Clarquist was incredibly helpful in moving the interview forward and helping Mr. Pitts to recall certain events or facts. Mr. Pitts' holding offense is a 1977 conviction for murder out of Cook County with a 150 to 300 year sentence. His mandatory supervised release date is February 17th, 2117, with a maximum discharge date being August 17th, 2120. Mr. Pitts was 24 years old at the time of the offense. He's currently 72 and has been in IDOC custody for 47 years now. Mr. Pitts was last heard at en banc for parole consideration 6 months ago on October 31st, 2024. Statement of facts. On November 30th, 1976, the victim, Jerry Keene, worked for People's Gas Company and was making a service call at the time with another employee, Winston McCain. The service call was for a gas leak at the residence where the petitioner, as well as Edward Stewart, were present. All 4 individuals proceeded to the basement to inspect the furnace. The victim, Mr. Keene, had trouble removing the furnace panel, so his coworker, Mr. McCain, began to proceed upstairs to retrieve a screwdriver. Mr. Pitts then snuck up behind Mr. Keene and began stabbing him. When Mr. McCain heard Mr. Keene scream for help, he immediately returned to the basement and witnessed Mr. Pitts attacking Mr. Keene. He saw Mr. Pitts' arm around the victim's neck, hitting or stabbing Mr. Keene in the chest with his right hand. Mr. McCain ran outside to radio for help, and the petitioner fled, later disposing of the knife. Mr. Keene was found lying dead on the floor with bloodstains all over his body. He was transported to St. Bernard's Hospital, where he was pronounced dead upon arrival. It was determined that he had been stabbed 23 times in the back, neck, arm, chest, abdomen, and thigh. Mr. McCain gave the police a description of Mr. Pitts. Officers learned that Mr. Pitts was the attacker and had spent the night in a vacant building. He was arrested the next day. He was initially found unfit to stand trial. In 1977, he was diagnosed with paranoid schizophrenia and transferred to the Illinois Department of Mental Health for treatment to restore fitness. He received treatment at multiple facilities until ultimately being declared fit to stand trial in 1978. On May 1st, 1979, the petitioner was evaluated by judge's order by the Forensic Psychiatric Program. He was diagnosed again with paranoid schizophrenia and partial remission with medication and was again deemed fit for trial. After returning to Cook County Jail and medication being discontinued, the petitioner admitted to a recurrence of disturbing auditory hallucinations as well as some suicidal thoughts. He stated the auditory hallucinations came from within, such as, quote, "Eddie, let me out." Despite the hallucinations, the petitioner was found to be fully aware of the charges against him, of the acts he had committed, which he ascribed to forces and pressures within him, and the nature of and purpose of the trial proceedings. Medications proved to improve his spirits while the hallucinations remained mild. Mr. Pitts pled not guilty by reason of insanity, which was not accepted, and Mr. Pitts was convicted by a jury and incarcerated in 1980. The state's attorney at the time argued that if Mr. Pitts were ever to be considered for parole, that he should receive a full mental health evaluation to be reviewed for civil commitment pursuant to the Mental Health Code. Mr. Pitts did appeal his conviction, and in 1982, the appellate court affirmed the conviction and the sentence. Mr. Pitts does seem to acknowledge the facts of the case, although we didn't discuss the details further this year. Mr. Pitts maintains that he is sorry for what occurred. He has historically shown remorse, including sorrow for the victim's family. In the past, he argued that he suffered from hallucinations that day and feared that someone was going to kill him. He felt the compulsion to kill them before they killed him, and described his hallucinations as perceiving the servicemen to be dogs and seeing Satan with the 2 dogs. Prior to the offense, Mr. Pitts describes being raised in a church that taught mysticism to him as a child. He states he grew up in a slave environment in the South where he picked cotton instead of attending school. He ultimately joined the Job Corps and traveled the country working construction in multiple states, including Kentucky, Florida, Mississippi, and eventually came to Illinois, Chicago, where he worked for the local 150. At different points in the interview, Mr. Pitts expressed his frustration with the Prisoner Review Board for not releasing him despite being in custody for 47 years. He does not believe that we as members are using our sense to properly determine threat levels. He argues that the Eddie who committed the crime is gone, and he is just an old man now. He stated he doesn't want to die in prison and that the board is treating him terribly. He later shared that the board is cheating him and that he struggles with our denials. He believes the board is doing him wrong intentionally, and he believes race may be a factor. Because Mr. Pitts seemed focused on the notion that the board's issue is rooted entirely on the holding offense, he was reminded that his 2022 violent assault ticket was a major factor in considering public safety. Mr. Pitts made it clear that he sees himself as the victim of that incident, having to defend himself from an attack. He stated that he was very frustrated with the October 2024 denial. As far as criminal history is concerned, Mr. Pitts' only prior offense on record includes a 1975 conviction for unlawful use of weapon, for which he was sentenced to probation, and then while on probation was arrested for an assault that was ultimately dismissed. Switching to his institutional adjustment, as for familial support and history, Mr. Pitts has no emergency contact or next of kin, but does maintain a visitor list. His last in-person visit was with his sister in May 2024, preceded by a visit from his nephew in April of 2024. Mr. Pitts does receive financial support from family. During the interview, Mr. Pitts had to be reminded that his brother had passed away recently. Mr. Pitts is incredibly physically fit for his age. I would argue he states that he exercises regularly in order to stay alive, and those are his words, and describes his workouts as hundreds of repetitions at a given time. He did have a successful hernia surgery in October of 2024 and reports having some issues with a knot in his knee. At this time, I will make a motion for us to go to closed session to discuss any confidential matters, including any mental health history and confidential opposition. Aye.
Again, I'm going to have to ask you to leave and take all your belongings. You'll be invited back shortly.
All right, we're ready? Okay, I will pick up in his institutional adjustment. As for Mr. Pitts' programming, he was involved in arts and sports-related programming from the 80s to the early 2000s, with a preference for exercise, as he found it therapeutic. He is free to request academic program enrollment, but there is no indication that he has currently. He is waitlisted for Money Smart at the moment. As already mentioned, Mr. Pitt's disciplinary record continues to be a point of concern, largely stemming from the 2022 incident. He had 2 pages of tickets on the old forms, including multiple tickets in SEG for dangerous contraband, an assault of an inmate ticket, and gang activity. He has 2 pages from 2000 to present that include an 06 dangerous contraband ticket for an altered razor blade, a 2012 contraband for homemade ropes and an altered blanket, 2014 contraband for needles, 2021 major ticket for disobeying a direct order for refusing to enter his cell and lock up that resulted in 7 days of segregation, and lastly a 2022 violent assault of a person ticket, which we have hinted at. The facts around that ticket include a witness observing the assault, which took place in the in the healthcare unit inside of a cell. The witness observed Mr. Pitts throwing closed fist punches to the victim, who was lying on the floor. The victim attempted to defend himself and stop the assault by throwing a chair. Mr. Pitts was then seen yelling at the victim to stay down while continuing to throw punches. Mr. Pitts admitted to punching the victim in the head repeatedly each time the victim tried to get up, until Mr. Pitts eventually just walked away. IDOC found the witness credible. The victim was transported by ambulance to the hospital, but the head injury was so severe that he was transferred again to OSF St. Anthony's for a higher level of care. The victim suffered from a brain bleed and required a craniotomy. During our interview, Mr. Pitts stated that he felt the need to defend himself. He claims the other individual threw a wheelchair at him. He felt as though the victim could have hurt him and therefore needed to protect himself from further attack. Mr. Pitts stated that the victim was 80 years old, but was very fit. He stated that he was scared of the victim and couldn't act like a coward. Later in the interview, he argued that the 2022 ticket was a plot against him to stop his parole. He stated the victim had a mental problem. He then admitted that he really couldn't remember much about the day of the ticket at all. It was clear his memory issues had made it difficult to recall any details surrounding the event. Mr. Pitts further made statements that he will protect himself. He will not let someone kill or harm him. When asked what he meant by those statements, Mr. Pitts clarified that he envisions protecting himself by ducking or covering himself. He argued he is in danger due to his age, both in the prison as well as out in the community. Per the offender overview done in December of 2024, the petitioner has not had any disciplinary reports since transfer to Lawrence. Mr. Pitts shared that he has enrolled in school at varying institutions over the years, but there isn't anything he is attending at the moment. He currently studies law on his own. He also has held a number of job assignments from the 80s through the 2000s. Per the offender overview again from December of 2024, Mr. Pitts is currently maximum security with no escape risk. He is also A grade in general population, although he resides in the infirmary unit. As far as parole plans are concerned, Mr. Pitts continues to maintain a parole plan based on admittance to Balmoral Nursing Home, which is a skilled nursing home with programs for mental health and dementia. This is an IDOC-approved host site with residents who were released under the Joel Coleman Act. That said, there were concerns even 6 months ago about the facility not rising to the level of security needed for a patient like Mr. Pitts, based on recent events such as the violent assault, and concerns for the safety of both staff and other residents. Mr. Pitts stated he would like to be paroled to a place where he can work his mind, create things, and make art. Mr. Pitts has letters of support and offers of post-release services from NAMI Chicago as well as the Illinois Prison Project. Cook County does oppose this petition, but I will let them speak for themselves here shortly. Mr. Pitts' first year of consideration for parole was in 1988. He has been heard 23 times prior to today, with the last hearing being on October 31st, 2024. He has received 3-year sets in 88, 99, 02, 05, 09, 13, and 16. Mr. Pitts began receiving votes in favor in 2019 when a motion to grant failed with a 3-8 vote. This was followed by a motion to deny prevailing with a 7-7 vote in 2020. A motion to deny prevailed by an 11-3 vote in 2021, and in 2022, a motion to grant failed by 3-5. Since the 2022 violent assault ticket, a motion to deny prevailed by 10-1 vote in 23, and a motion to deny prevailed with an 8-2 vote in 2024. With that, I will yield back to you.
Thank you. Any questions for Mr. Bolin? Hearing none. Have you been sworn in yet? And the state's attorney might want to be sworn in as well. She's already been sworn in. Go ahead.
Do you solemnly swear or affirm that the testimony that you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yeah. Just an initial matter, I was not informed that the state's attorney had objected. I was not provided with a letter. Just so you're aware, the state's attorney has not objected until now. There is a new state's attorney in Cook County. It was elected in November. I assume it's related to the change. You know, like they say, elections have consequences. So I assume now that the state's attorney Burke is objecting, but I did not receive any notification of that. I can guess what it says. I can tell you, I'm glancing at it. I see they said his release would be cause a substantial risk. It's what I expect him to say. They also, I know you've been previous. I have not until now. Talking about the 2022 fight, which is 3 years ago. I'll talk about in a second. But again, you know, hey, elections have consequences. Now they're objecting. The private state's attorney, as recently as October, did not object. So with that, yeah, thank you. But I would like a copy of that sent to me, please. Also, I did send to the PRB operations email to Mr. Bolin on April 17th about Eddie Pitts's updated parole plan. So I don't know, you know, we're told to send PRB operations email. If I don't have your email personally, I'm not going to infringe on your privacy and try and figure out what it is, although I have emailed with specific board members. But in that April 17th email, I informed the board via Mr. Bolin, which I put in the subject line email for Mr. Bolin, Eddie Pitts, that Mr. Pitts has now been admitted to Central Nursing Home, which is a sister facility of Balmoral, which a couple of the board members toured in October. And this is critical because it's information it appears you don't have. I toured the facility on a couple days before that, along with Marion Seerig, who represents Mr. Pitts, is unable to be here today due to a family matter. But in that nursing home, Mr. Pitts will be confined to the second floor, which is for dementia patients and psychiatric patients. It's locked. This is essentially a slightly less version of what he's receiving right now, where he is in the infirmary listed as chronic infirmary status at Lawrence. So just some perspective, Central Nursing Home would first, upon his admission, have Eddie, and this is required by statute, be subjected to the Identified Offenders Program. That is for a risk assessment, okay? Illinois State Police and forensic psychologists from the Illinois Department of Public Health would assess him for any risk. He will be in his own room. That is without question. The staff at Central told Ms. Searing and I that is where he would be placed. They actually place all new residents in a single room, but given Mr. Pitts' history, which they're aware of, we sent them all the records that they requested, he would have his own room. It's on the second floor of this facility. The elevators have a code, which only the staff is privy to. Mr. Pitts has dementia, so even if he observed someone typing in the code, I don't think he would remember it. The doors are locked. It is staffed 24 hours a day, so someone would be watching Mr. Pitts. There is a staff psychiatrist, which is critical. The board is concerned about Mr. Pitts' history of mental illness, and there's no question that is what the offense itself, the holding offense, is related to, his history of schizophrenia. He is not getting any psychiatric treatment in Lawrence, presumably because Lawrence thinks he's doing okay. If Lawrence thought that Mr. Pitts was a safety risk due to his mental illness, they wouldn't currently have him in a suite in the infirmary with 3 other inmates. And he's been there since, I believe, late August. He also would have a general practitioner. As I said, he's on a floor of a dementia residence and mental illness individuals. And also, he would have an inability to check himself out of the facility. His nephew would be his power of attorney, and the staff told us he cannot leave the second floor without an attendant, staff member, approved list of people, which could be his attorneys, staff from NOMNI, which works with people with mental illness, staff from the Illinois Prison Project, their social worker has worked with Mr. Pitts. So he's not going anywhere. He's really on the second floor of this facility. So it is a step up from where he is currently, which I can tell you from a Sun-Times article published in the last few weeks, we spend $49,000 a year on each inmate in the Department of Corrections, and that's not with the full-time nursing care that Mr. Pitts is now receiving. So I don't know what the number is. You might know from doing Joe Coleman petitions, but it's huge. He is eligible for Medicaid. This is a Medicaid facility. They have space for him right now. I can't tell you in a year from now they will. If their Medicaid funding is cut, I don't know, but they can't accept him now. The other thing is he will have a parole agent. So the parole agent can also tailor what Mr. Pitts can and can't do. The parole agent can stop by at any time. The parole agent can search his room. Anyone on parole can have their room searched, their body searched. So he will be secure. And again, he will have a risk assessment done by the state police, law enforcement. So this is not a situation where Mr. Pitts, if granted parole, will be walking out the door of Lawrence. We feel like this parole plan is actually better than the one we had at Balmoral because, and I was on the floor, you can't get out of there, including me, unless you know the code. And he would actually get medical treatment, which I think you all have heard his case a few times, most of you by now. He is getting medical treatment in Lawrence, but not, the treatment for dementia is what it is. I'm not that familiar with it, but he certainly is not getting any psychiatric treatment. And he would see the staff psychiatrist within, days of his arrival. So I think that's very important. Right now, his diagnosis at Lawrence is dementia. He has some sundowning, which means he's up all night. And then, I don't know if anyone's familiar with dementia, there's sundowning, which means you're awake at night, excuse me, and then you're sort of awake during the day. His nursing diagnosis says impaired cognition, risk for fall injury. There's progress notes made twice a day by the nurses, and I would note that they always say he's calm, cooperative, pleasant, and I think that says something about Mr. Pitts in terms of him always being compliant with the staff and being told what he needs to be doing. So in addition to that, I do want to touch on, I know that the board is concerned because of the incident at Dixon. Understandable. The reports, there's a confidential informant who saw the offense as it was in progress. The confidential informant did not see what initiated the offense, the incident. We don't know. Mr. Pitts has always been consistent, much like what he said about the holding offense, is that this individual who was 80, he still is at Dixon, I looked, and the guy threw a chair at him and called him a racially derogatory name, although they're both the same race. But it has been 3 years since then, as Mr. Bolin mentioned, I should mention too, as a consequence of that fight, he was put in segregation for 6 months, so he was punished for that. After that, he was designated as SMI, which means severely mentally ill. He would not be put in segregation for a similar incident at this point if it was somehow linked to his mental illness. Again, he has had no incidents in over 3 years now. It has been 3 years. In addition to that, as Mr. Bolin mentioned in his interview, he asked Eddie, or Mr. Pitts, what if someone does something to you? And the first thing he said, and Mr. Bolin can verify this, is, well, I would look for a correctional officer. And then, what if no correctional officer is around? Yeah, I'd dodge, try and get out of the way. And then the question was, well, what if there's no one else around and you can't get out of the way? And Eddie did say he would defend himself, as I think anyone here would. There are dangerous people in the Department of Corrections, clearly. Several years ago, I know one of the board members who's no longer here said, while reviewing Mr. Pitts's tickets, he said, considering who Mr. Pitts is incarcerated with, and this includes 20 years in general population, overall his disciplinary is not too terrible given his time in custody and who his, the people he's congregating with, which are, in prison. So I think that the key points here should be, we should consider the medical care. Mr. Pitts has been in prison now It'll be 48.5 years. If he's denied parole today, even though we have a good parole plan, it'll be 49.5. We're heading towards 50. You know how many CEMA number cases we have left? Not a lot. He is one of the few inmates in Illinois, one of the longest serving. I don't think anyone could say Mr. Pitts is one of the worst of the worst. He's not. He is mentally ill and deserves to have some mental health treatment, which he will get on the secured floor at Central Nursing Home. And again, you know, appealing to some sort of financial, you know, comparison, he's costing and has cost the Illinois taxpayers a lot of money, where he could actually, it's a win for the taxpayers because now he's moved off their dime to a secured facility where he cannot leave the second floor without an attendant or an authorized visitor. This is important, and it should be considered because Mr. Pitts' cost of incarceration will continue to increase as his dementia grows more cumbersome, and along with other just issues of him being in his 70s. He's doing physical therapy right now for his knee. So with that, if you have any questions, I'm happy to answer them. I know we were here on Halloween, and I'm sorry, Mr. Bolin, that you didn't get that email. I thought it was odd you didn't respond, but I didn't want to overstep my boundary and track you down to see if you got it. But I did relay all this information a couple weeks ago. The other thing is, he can have a 90-day hold. So if you do grant him parole today, we still have to do the Maximus assessment, which you might be familiar with. The only reason we didn't do it beforehand, although they have said he can live there at Central, is because it's a lot of work for the social worker at the Illinois Prison Project, and she has, you know, limited resources and time, and we want to make sure she is able to use that to her best ability, given the clients that she also represents through her work there. So it's a limited resources, so we thought we'd wait. But they do have space for him. And actually, I think they have 240 beds, and right now they're at like 175 capacity. It's in Chicago. You know, you could go see him there. We can put you on the visitors list if you're concerned. I know 2 Chicago board members, unfortunately, are not here today, so that makes it more difficult for Mr. Pitts because as came up earlier, yes, indeterminate sentencing, he needs the majority of votes on the board, and we're missing 2 board members today, so that makes it more difficult for him to get this opportunity for release. And if he's denied parole today, it's another year. And I don't know if I can get this parole plan next year.
I want to commend you for representing Mr. Pitts and for finding this housing arrangement, which has been something that we've been searching for people who have these kinds of mental illness issues. So thank you for that. I just want to confirm that if he did get paroled and he went to that location, he would have a fixed parole term of 3 years or 5 years? Which
it's
is
5.
5 years. And then at the end of the 5 years, assuming he's still living, at that point, would this nursing home have to be his voluntary choice to stay there, or face a civil commitment for involuntary commission to a state psychiatric facility?
No, his nephew would have his power of attorney. He can't break, Eddie cannot, Mr. Pitts cannot break the contract. His nephew Zebedee Pitts would be his power of attorney. And this nursing home does offer hospice and end-of-life care. They told us he could reside there indefinitely.
But it would be the nephew's decision about whether he would remain there or
yes,
go somewhere else.
But the nephew cannot, much like I wouldn't be able to, cannot care for Mr. Pitts' needs. So I can't speak for his nephew, but the family can't take care of him given his physical and mental health issues. So they would want him in a facility like this. And it's really a miracle that this is available to him.
Thank you very much for finding this place.
Can I clarify? Power of attorney is different than guardianship, though, correct? I mean, Mr. Pitts can still determine that he wants to leave. Power of attorney works in concert with the individual just to interpret and to support his needs.
Well, I mean, the reality is Mr. Pitts wouldn't be able to make those type of decisions for himself. So
Right.
Guardianship, right now, power attorney, the facility said power attorney he cannot break the contract. And I'm being serious when I'm saying he cannot get off this floor without
so what
someone.
you're saying, there's another contract in addition to the power of attorney established
With
by
the nursing home.
Central Nursing Home.
Yes, that's what they told me, yes.
So if he breaks the contract, that's a revocation, and he comes back to facility.
If he breaks the contract and leaves the facility, the parole agent can revoke his parole immediately.
Okay.
And they're in touch with everyone. I mean, he would be in touch with, the facility would be in touch with us, NOMNI, staff from IPP, the board, if anyone wants to go over there.
I understand. And the nursing home understands his medical, his
Yep.
mental health needs?
We sent them the records, and we talked to them about it. We said, he's diagnosed with schizophrenia, but he hasn't been getting psychiatric treatment, which I think is critical too. I know you're worried about him being a safety risk, but Lawrence is not treating him for his psychiatric illness, and my guess is because this is true for almost the majority of the time he's in the general population. He keeps to himself, and he tries not to engage with people. And actually, he told me, I talked to him last week, he said, someone tried to talk to me, so I just left. He knows the board is worried about him getting another fight, I can assure you. And he did say to me last week, too, I do what the correction officers say, and I think that's true of the staff. I don't know how much he would really understand, given that in Central, like I said, is a step up from Lawrence. And we've said to him, you'll have to go to this place if you're going to parole. I don't necessarily know if he would understand that there's a contract now. That's something, though, the psychiatrist and the general practitioner can work with him. They can certainly answer questions you have to ensure safety of Mr. Pitts. And keep in mind, too, the nursing home, because we asked them, we said, what do you do if someone in a nursing home, they start disagreeing with each other? Because it happens. If you're familiar with dementia, some people get angry with dementia, and it's, they've changed their personality. It's really tragic. Nursing home has an incentive not to have any resident issues. And they did tell us Mr. Pitts will be in his own room, but if there's any sort of disagreement, keep in mind Eddie doesn't go out of his way to make conversation with people. They intervene immediately. They have people on staff 24 hours a day.
I have a question about this contract you're talking about. The contract is between who?
The nursing home and his power attorney.
Okay.
That's my understanding.
Okay. So he would be placed on parole, and then the family would be agreeing that he be placed, and they're the ones who do the contract. But in fact, a power of attorney can be revoked by the person who gives it. It's not a guardianship. So if he improves and a court finds that maybe they go for commitment and a court says, no, we're not going to commit him, so then he can walk.
No.
Now, he could be revoked from parole.
Yeah, and a post for parole has to be approved. So he's 72 right now. He's turning 73, so he'd be on parole at least 5 years, so he'll be 78 when he gets off parole at the earliest. He just said he's one of 11, and he's lost multiple siblings. I don't know if Mr. Pitts will be alive in 5 years, or any of us for that matter. I don't know. I don't have that. I understand your concern. I'm not being dismissive of it, but I can assure you the family wants him in a safe place where they're treating his medical needs.
And then by being on this second floor that's locked, I take it if he's treated, he's on medication, he might be improved and moved to the first floor?
No, because he has dementia, and it's not just for those diagnosed with mental illness, it's their memory care. Second floor is also for dementia patients, which my understanding you don't get better from dementia.
All right.
It's secure because they don't want these individuals, the residents, wandering off or something. They do have a liability concern, the nursing home.
My last question, you talked a lot about the cost. And so my question is, what's the cost of him staying in this nursing home with this specialized care?
Well, it's Medicaid dollars, that's federal money.
I realize that, but it's still dollars.
Right.
So what are we talking about?
Well, the Sun-Times article I saw said that and they were talking not necessarily, they were comparing prison to just public facilities. I think they said it was like $25,000, so roughly half the cost. I don't know the exact number.
I think that might be true for an assisted living, but I don't think that's true for someone in a facility like you've described, at least not that I have experienced. It's quite a bit more expensive than what it would be, but that's not the major issue here.
Right,
so.
I understand. And I don't know, sometimes, when a cost is listed, what's Medicaid paying versus private insurance?
Yeah.
It's all a bit opaque to me. My understanding, it is cheaper than prison. Whether it's $1 cheaper or 10,000, I don't know. But it would be Medicaid. And they did tell us at Central he could get disability, so he would have $30 a month, which breaks down to like 15, or I did the math, $12.50 a week.
Yeah. Okay.
But he cannot leave without an attendant. Similar to his current situation, except he can't leave permanently. I mean,
Yeah. Before you have any other questions?
No.
Could we hear from the state attorney's office, and then we'll have Mr. Bullen make his motion?
Yes, the Cook County State's Attorney's Office does oppose the granting of parole to Mr. Pitts. It's the state's position that there is a substantial risk that he will not conform to the reasonable conditions of parole, as has been discussed in the last hour or so. A big concern of ours is that violent assault in 2022, that was extremely violent. The victim had brain damage, as you guys talked about. We also believe that granting Mr. Pitt's release would deprecate the seriousness of this offense and promote disrespect for the law. If a trier of fact finds that the murder was accompanied by exceptionally brutal or heinous behavior indicative of wanton cruelty, the sentence can be up to natural life in prison. In this case, the judge did find that this was exceptionally brutal. And brutal includes conduct which is grossly ruthless, devoid of mercy or compassion, or cruel and cold-blooded. And this crime was that. Mr. Keene was a public servant. He was just doing his job, and Mr. Pitts stabbed him 23 times. This was very violent, and given that he attacked a different person in a very violent way 3 years ago, the state is very concerned and believes that the risk is too high that Mr. Pitts would engage in further violent behavior if released. We also believe that his release would have a substantially adverse effect on institutional discipline. As I said, there is no reason to believe that he would abide by the reasonable conditions of parole, considering the mental health issues that he suffers from, along with the dementia. Aggression is a common symptom of both of those conditions, and he has shown that he is violent, even very recently. And finally, we ask, pursuant to 730 ILCS 5/334G, that the board considers all prior letters protesting parole, as well as any prior recorded statements of protest by our office in the past, and any interested parties, including Jerry Keene's family and friends, some of whom testified yesterday at the protest hearings. Thank you.
Can I say one final thing in response to the state's attorney, since they're speaking about the fence? Also, what she forgot to say is that sentencing, a factor in mitigation, is subsection 16. At the time of the offense, the defendant was suffering from a serious mental illness, which, though insufficient to establish the defense of insanity, substantially affected his or her ability to understand the nature of his or her acts to conform with her conduct requirements of the law. And these two incidents, the holding offense and the incident in Dixon, were 46 years apart, 45. And we have measures in place to address the state's attorney's concerns, because now he will have a psychiatrist, which we all know was the underlying concern with his initial offense. And I don't think he should be punished further because he's getting dementia, and dementia patients can be violent. That could be true. That I take issue with. And I'll just leave it at that.
Okay. Mr. Grubbs.
You and I spent a lot of time on Eddie Pitt's case last year, and I want to echo what Mr. Heaton said, in that I think that this entire board has appreciation for what you and Ms. Sebring have done to advocate for him on a pro bono basis, so thank you. Second, obviously it's not a requirement that the board tours a host site option, correct? But knowing that I made a trip to Chicago last year to do just that, and then had another board member give a secondary analysis of last year's host site option, I guess I would have hoped that you would have given us that option this year. And Central sounds exactly like what we're looking for, but so did Balmoral until I toured it. And so that's where my reservations lie, not in your analysis of it, but in my inability to take a look at it.
Right. If I could address this, this is why I did send the information to the PRB operations email, which is what I'm told to communicate unless you have individually given me your email. Again, I don't like to intrude on your space, but I'd be happy for that. That's why I sent the information. I was disappointed to see that 2 of the Chicago board members aren't here. It has to be approved as a host site. It hasn't yet. So what could happen is that Mr. Pitts is granted parole today, and if you read the statute, he can be held in the Department of Corrections for up to 90 days while the host site is being approved.
Well, are you making a motion to continue this?
No, I would like him to be.
Testimony?
No, I would like what can happen is like I just said, if you look at the statute, that if the host site, which it has to be approved still by probation and parole, if Central is approved as the host site, it still has to be. So say you grant him parole today. He's not going anywhere tomorrow because the host site isn't paroled.
But the issues between what the board is concerned at and the reintegration group is concerned with are 2 separate things. They're only looking at whether or not he has a host site available. The board is concerned about the security of that host site.
Well,
So they're 2 separate things.
Sure, but I would assume there's some communication back and forth. But I'd be happy for the board to look at the facility. I was surprised. I didn't know with like fire codes and whatever.
Let me make a suggestion to you. I think you're getting a clue here that if you were to ask us to postpone this decision, to give us time to go look at it ourselves, your chances of success are greater. So
That's
consider
fine.
making a motion that this case be reconsidered.
In 90 days, or how soon would you like it to? I mean, as soon as someone can come see it, I'm happy to arrange it with the facility. And then, I guess my question is, then do we come back for the next en banc, or does or probation approve it as a host site? Balmoral was approved because IPP had other clients there, but they haven't placed someone at this facility yet. But I'd be happy, you can come look at it, check out the code for the elevator and the doors. It was something I was thinking of you, Mr. Grubbs. We were asking these questions with you in mind, because we know you're concerned and we understand it. We also are concerned about Eddie's safety. I don't want Mr. Pitts walking out the door there. I would be concerned about him. And people in his state can be victims of crime because they're more vulnerable. So that is acceptable to me.
Mr. Grubbs indicates he's going to be out for next month, so it would have to be the following month. But if you wish to proceed, we'll go ahead and proceed at this point.
No, I want to enhance Mr. Pitts' chance of getting out of prison after 40.5 years. So of continuing his en banc to a further date, once board members can look at the facility, of course, this is, the best parole plan that we've found for him, and I'm not sure there's a better option available anywhere.
For what it's worth, if this is my motion and I need to be taking a look at this facility, we're already fully scheduled out in May. I've got quite a bit of time off in June. I've got a little bit of concern with being told, hey, go drive to Chicago and do a thorough analysis of this site with...
Will you be there for clemency hearings? Because
we just went through clemency hearings.
I don't know if you're coming up in July.
It'd be in
July.
July. If you want to continue the motion, and knowing that we would continue it till June hearing.
And if you can't check the facility out by that, we can extend it to the July en banc?
Yes.
Okay.
But we would do that.
Okay.
So you have a motion to do that?
I would suggest July myself if this is on me. I've got a lot of time off in June. That'd be a burden.
Okay.
I think it's a good idea. I really want to see the place, and I'm very grateful that you guys have worked so hard to find a place like this. And we want psychiatric options that are secure, and so thank you.
Yeah, we were just talking about this, that we need a place that does provide that. So all the board is very interested in this.
Okay.
So based upon your motion, I'll make the motion. Motion to
Mr.
continue
Bowen?
the case to look at the mental health treatment center. Do I have a second?
Second.
Okay, second by Mr. Heaton. Those in favor respond by voting aye.
Aye.
Aye. Any opposed? Nope, the ayes have it. We're continuing this case to go look at the case, and then we will notify you to be sometime in July. And if we can't get to it before then, we'll kick it over.
Okay, I appreciate it. It's better than getting a one-year set.
We do have the state's attorney's objection already on, but if you want to come back in July, we'd love to have you.
Okay, I just wanted to clarify, so we're coming back in July for this case, or is it
We're
June?
going to come back for, yes,
July?
July.
Okay, thank you.
And if you could send send her your protest letter so she would have it for the future, that would be great.
Thank you, I appreciate it.
You want to stay around for this one or want to move?
If we can do it, let's get it done.
All right.
Jeff did the work.
Go ahead, but we got to be going. It's 52 minutes for the presentation. Yeah. The last case we're going to call is Ricardo Norales, so whoever's present for that case needs to come up. Do we have anybody? We don't have anybody? Mm-hmm. Can we get all the signatures so Heaton can sign them? Okay.
Are we taking a break? Can I just
Short
run a?
one. Go ahead.
I just gotta go to the bathroom real quick.
Ricardo Norales, inmate number C61253. Mr. Grubbs.
Mr. Grubbs, before you get started, can I state something on the record for this case?
Sure.
I did conduct the protest hearings for this case, and once I started the protest hearings, there was a witness that I recognized that I went to high school with their son. And so that quickly I recognized a conflict of interest, so I will be recusing myself from the vote for this case. But I'll still be able to provide the protest testimony, but I just want to put that on the record.
Well, wait a minute. Do we have a quorum for that? Yeah, because at that point we're down to 7. 7 out of 10 is still the majority. Okay.
Is it the majority of the board or the majority of the board members seated?
Majority of the board members appointed. As long as you have a majority, you have a quorum. Okay. That's what the statute says. All right.
Okay. Are you ready? This is a presentation of the file of Mr. Ricardo Norales. I interviewed him on February 13th. He's currently serving a 100 to 200 year sentence for murder, 100 to 200 years for rape, and 100 to 200 years for attempted murder. Mr. Norales presented following a 3-year set, last appearing before this board in May of 2022, where he did not receive any votes in favor of parole release. He's most recently been incarcerated at Shawnee Correctional Center since October of 2003, according to the most recent offender overview provided by the Illinois Department of Corrections, November 2024. Mr. Norales is classified as A-grade, medium security. His escape risk designation is low. He's 69 years of age and he's been incarcerated for 50 years. His projected mandatory supervised release date is currently not until the year 2065. Statement of facts. On or about November 25th, 1974, when Mr. Norales was 18 years of age, he, along with co-defendant James Bremer and a third unknown assailant who has never been identified, gained access to the apartment of 35-year-old female Joyce Britt on West Crystal Street in Chicago. The 16-year-old daughter of Miss Britt was also present. Mr. Norales was known to the juvenile victim, and she was later able to identify him to police authorities. During the attempted robbery, both victims were beaten and raped. The juvenile victim was raped by Mr. Norales, co-defendant Bremer, and the third unknown assailant. At the conclusion of the sexual assaults, Miss Joyce Britt was shot 5 times and died as a result of the gunshot wounds. In an attempt to silence the sole remaining witness, Miss Britt's juvenile daughter was shot 5 times, but miraculously survived the attack by pretending to be deceased. Following a bench trial, Mr. Norales was found guilty of murder, attempt murder, and rape. In April 1976, he was sentenced to the aforementioned sentences for the murder, attempt murder, and rape, all to run concurrently. His statement as to the offense: during my interview with Mr. Norales, he failed to acknowledge his role in the rape and murder of Miss Joyce Britt and the rape and attempt murder of her juvenile daughter. He only acknowledged knowing them and asserted he is innocent. He acknowledged knowing co-defendant James Bremer, but indicated he had no knowledge of the third unidentified co-defendant. Criminal history record information regarding Mr. Norales beginning when he was a juvenile and progressing into an adult criminal record, which includes burglary, robbery, aggravated assault, and an unlawful use of weapons. He was on probation when he committed the murder, attempt murder, and rape for which he's convicted of in 1976, being considered today. Institutional adjustment. According to the most recent IDOC offender overview of 2024 and Mr. Norales' testimony, he only has minor health issues and is not in need of mental health counseling. He has been unassigned for around 10 years and has not participated in any programming for a great number of years. His last disciplinary ticket was 2019. Mr. Norales has not had any visitors since 2018, but indicated he attempted to remain in phone contact with one of his sisters, as well as a former incarcerated individual he met years ago at Illinois River. Parole plan. Mr. Norales does not have a parole plan. If released, he would like to convince his sister in Chicago to allow him to live there with her. He would look for unspecified employment. Mr. Norales is not represented by legal counsel, but indicated he attempted to engage with an organization for assistance around 5 years ago, but didn't receive a response to his request. He would like a chance of being paroled, but acknowledged very candidly he has done nothing following his last parole hearing in 2022 to improve himself for consideration of parole release. Opposition to parole release. The Cook County State's Attorney's Office is here and has written multiple years with opposition, though until this year none has been received since 2017. Today's opposition from Cook County is documented in an April 2025 opposition letter. There are current and compelling letters of opposition from immediate family members regarding the impact they continue to suffer based upon the criminal actions of Mr. Norales. As far as en banc history, Mr. Norales was first considered for parole around 1984, and he's received a continuous number of multi-year sets over the past 20 years. We did have protest in this case, Mr. Chair. I don't know if you want to hear from the Cook County State's Attorney's Office, and then we could go into closed session.
Yeah, that would be fine. Or you can stand on your letter.
Yes, I can elaborate if you'd like me to, but yes, I can stand on the letter if that's what you prefer.
We don't.
Okay.
Thank you.
Mr. Chair, my motion is to go to closed session to be able to take protest testimony.
Motion been made second. Those in favor? Aye. No opposed. We're taking a short break. Be back in like 5 minutes.
Mr. Chair, this presentation of the file for Mr. Ricardo Norrells may have been short, but I want to assure you that, and all involved, that an untold amount of time has been spent considering this petition. I do truly wish our system of justice and society had alternatives in place for incarcerated individuals like Mr. Ricardo Norrells, who's been incarcerated for 50 years. Perhaps someday we as a society will be able to provide appropriate yet secure alternatives to incarceration in a penal institution for those similarly situated. But based upon my review and for all reasons previously stated, it is my assessment, despite his length of incarceration, Mr. Ricardo Norrells has not advanced to a point where he should be granted parole, at least at this time. Therefore, my motion is to deny the parole release of Ricardo Norrells.
Motion's been made and seconded to deny parole. Ellen, would you please take the roll?
Mr. Grubbs?
Yes.
Mr. Heaton?
Yes.
Ms. Tarones?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
Yes.
Mr. Coates?
He abstains.
Ms. Globoker?
Yes.
And Mr. Tupy?
Yes.
I have one more motion, Mr. Chair.
Motion to deny parole passes by a vote of 7-0 with 1 abstaining.
Motion for a multi-year set. Since around the year 2003, Mr. Norrells has received 4 3-year sets, 2 5-year sets. I will say during my time with him, I felt like we finally reached a point in the connection, a point of connection towards the end of the interview. I spoke to him at length about some of the things he could do to improve his ability to work towards parole release. And he was finally willing to accept contact information for advocacy organizations from whom he could seek legal or other guidance from. He seemed to accept this challenge. However, we also need to consider the victims in this case and the gravity of the impact that this crime has had on them and continues to have on them. And in light of the fact that Mr. Norrells has taken no steps at this point to involve himself in programming or parole planning, it is my assessment another 3-year set is the most appropriate. So that is my motion for a 3-year set.
I'll second it.
Motion has been made and seconded to deny parole for a 3-year set. Ellen, call the roll.
Mr. Grubbs?
Yes.
Mr. Heaton?
Yes.
Ms. Tarones?
Yes.
Ms. Tyson?
Yes.
Mr. Boland?
Yes.
Ms. Globoker?
Yes.
Mr. Tupy?
Yes. By a motion of 7-0 with 1 abstaining, the motion for a 3-year set passes. Do I have a motion for an adjournment? Motion and by Mr. Heaton, seconded by Mr. Coate. Those in favor respond by voting aye.
Aye.
No opposed. Motion granted.